17.
Yes.
My lord,
Taken
I-
the consent.
in this case, I have, my lord, last several occasions, they are taking time, my lord. So, instead of taking, time, my lord, again and again, lordship may fix a date after puja vacation, my lord, so that matter can be disposed of, my lord.
Give a date in November.
A fixed date, my
What
lord.
is the matter about?
This is regarding those casual workers, Your Lord. Okay. But we are not seeking regularization.
What are you seeking?
Seeking for engagement because, Your Lordship, we are covered by notification. The Lordship had last occasion said about the division bench order, which was till 93, but we are covered by notification after 94. Those who have worked for 5 continuous years from 94 to 2001, they can be given engagement if there is vacancy or they need the services.
Fix a matter, fix it in November.
Yes.
17, 18, 19.
Any-
No,
Analogous matter.
analogous,
Seven-
another 2 meters, sir.
4
4 meters, sir.
17, 18,
17, 18, 19, 20, and 21. All analogous.
17.
17, 18, 19, 20, and 21.
What is the point in fixing a date? You're
Let it be
taking
up to
adjournments.
4 weeks.
Why?
Lordship, there is certain difficulty of a senior advocate today.
Then why fix a date?
Let's-
Let it be admitted. It's for hearing, isn't it?
Yes.
Let it be in part 2 list. As and when it is convenient, you upgrade and make a mention. This listing business of on daily basis is burdening the system. Let it be in the part 2 list. As and when you're available to do the matter, you make a mention, fix a date, do it. It will remain in the list. It's convenient for you, all the councils. Item 17 to 21 be listed in the part 2 hearing list, in the next part 2 hearing list.
If the Lordship can give us-
And the councils are agreed that the matter can be taken up for hearing after the long vacations.
Oblige.
May
Oblige.
may it please the Lordship. Lordship, on behalf of Mr. S.K. Medhi, I'd beg to mention a bunch of matters. And I've taken consent, informed and taken consent of the petitioner as well. Item number 1 and 2. Item number 23, 24, 25.
You can't make a mention like that. You should have filed your applications before the registry. If there is a difficulty, you can't say that you've got a bunch of matters you want to make a mention because
Lordship, like he's going through a bereavement, and I've also circulated the slip adjournments.
all right.
In item-
These matters were listed, item 1 and 2. These are fixed matters. These are fixed matters.
These matters are old matters, my lord.
Then
And maybe yesterday they informed that his mother has expired. Oh, my God.
this is not a way to conduct matters. I am conscious of personal difficulties, but matters are fixed at the request of councils.
Yes.
Then this is not a case of he is appearing for the central government. There are other councils in the central government.
Yes, Lordship.
Why are they not appearing in the matter in his absence? We are adjourning it only for a short date. When is he likely to be free?
Lordship, he will be.
You do one thing, you go and inform the Deputy Solicitor General. Ask him to be present, we'll take up your matters. You ask him to be present in court.
Like,
May it please your lordship. Lordship, regard to item number 22, your lordship.
Sorry?
Item number 22 of daily list, lordship.
Hmm.
Lordship, as per order dated 4/8.
Yes, that is
Yes,
before
Lordship.
any other bench.
Yes, lordship.
Yes,
Yes, sir,
it has already been deleted.
Yeah.
Much obliged, lordship.
Can
I was not aware.
in this case.
Which case?
Yeah, item 22.
22, lordship.
22 has disappeared from the list by a subsequent list.
Lordship, we are
So
not
it is
aware,
wrongly
lordship. I'm
listed.
so sorry, lordship.
No, you don't have to be sorry. It was listed. Now a list has come. It has been shown to be wrongly listed.
May I please, sir? I beg to myself one contempt case for orders, madam, next Friday.
Friday orders, all right. Yes,
By this application, well, we have challenged the impugned order dated 4/9/2019 manner, by which the punishment has been inflicted upon the respondent for one stoppage of the one increment with cumulative effect.
Hmm.
What had happened, my lord, pursuant to an incident, an FIR was lodged against the petitioner, my lord. And after lodging the FIR, my lord, the criminal as well as departmental proceeding has been initiated against the petitioner. And subsequently, in the criminal proceeding, my lord, he was acquitted honorably by the honorable trial. And in the departmental proceeding, he was imposed punishment, stoppage of one increment, my lord. And the charges in the FIR as well as the charges in the departmental proceeding are same. My lord, the FIR is at page 24.
where is the order in the criminal court?
My criminal court's order is at page 60, my lord.
60.
60.
What were the points for determination?
My lord, my lord, kindly take page 72, my lord, of the judgment. The second paragraph. First of all, there is a total inconsistency of the evidences of PW1, the victim and
No,
the
you come to 61. These are the two
issues.
Witness.
points of determination.
My lord,
Page number 61.
yes. Whether the accused person 14th day of May 2018 at Chirang at the house of the victim Anjali Karji assaulted and used the criminal force on Anjali Karji, a woman intending to outrage the modesty of the said Anjali Karji by such assault or criminal force and thereby committed an offence under section 354 IPC. Whether the accused person on the same date, time and place had made the sexual harassment against the victim by making the physical contact and advance the involving welcome, unwelcome and explicit sexual overtures to her by making a demand or request for sexual favors and also had made the sexual colored remark to her and thereby committed an offence under section 354A of the IPC. And
Yes, then.
then, my lord, after the completion of the trial, my lord, it says
No,
held,
no, what is the finding?
my lord, pending, my lord, page 72, my lord,
Yes.
the second paragraph. First of all there is a total inconsistency of the evidence of the PW1, the victim and the evidence PW2, who happens to be one of the most important witness in this case. As per record, PW1, the victim stays in the quarter allotted to PW2, and it is admitted that PW1 was present in the quarter in the night of 14 May 2018, on which date the incident had happened. But as per the evidence, PW2 was also present on that night at her quarter. There is a total contradiction in this regard. PW2 has completely denied anything to happen at the festival. Further, even if assume that the PW1 has told the truth, it is on record, which has been proved from the evidence of PW1, the victim and IO, PW4, that the quarter had another 3 quarters in the same building, out of which 2 has been occupied by some people. Further, there are other quarter sentry bungalows present just around the place, but prosecution could not bring out a single witness to at least prove the presence of the accused persons at that place on the day of occurrence. Thus, there is a contradiction. There is no help from these other sources in this regard. On the other hand, as per the evidence of PW2, the next day she went to the office and talked these two Mono Mohilari, and she took her to additional SP, whereas Mono Mohilari has totally contradicted her. H1 SP of that time was not examined by the IR. It is on record that victim did not tell the incident of anyone except Monomohel in this office. But then now come the important part where the victim told that the complainant has been stated by the superintendent of the police of that time himself and told her to sign. He signed the same to the Raleigh PS. Now, if they consider the arguments of the defense where they argued that complainant was written by SP and then the same SP had sent to the OC and with a note in it or for OC concern is clearly shows some doubt. I have considered this same and considering the materials and deposition on record, the action of the then superintendent of police clearly creates doubt regarding the happening of the incident. If we consider the materials into entirety, the act of the SP also showed that he has taken extra personal interest in the case, or it is sent from the evidence of the PW3 that he went to bring the accused person from his office with the verbal order of the SP only. It is on record that he was working as OC Sidley at that time, and he done the same in the verbal order from the SP, and he did take.
Anyway, so you are you are acquitted. You are acquitted. You are acquitted of the charges.
Acquitted.
Yes.
And the 74 mallet, the last pending mallet.
Hmm.
Now, having considered the discussion above without going into the details of the ingredients of the alleged offense, there is a clear doubt seen as prosecution could not have even established regarding the presence of the accused person at the place of occurrence itself without any iota of doubt. Further, there is doubt emerged out regarding the veracity of the evidence of the victim, who invariably had supported both the allegation against the accused person. But as it is already been discussed, there are loopholes and lacunas in the story of the prosecution, and prosecution could not prove the case beyond reasonable doubt.
Now, where is the inquiry report?
Inquiry report is at page 44. Wherein the 6 witnesses has been examined in the departmental proceeding, and the 4 witnesses has been examined in the criminal proceeding, and the vital evidences are the same in the departmental proceeding as well as in the criminal proceeding. Out of the same evidences.
This was conducted when 35.
Yes. Before completion of the departmental proceeding, he was acquitted, and he duly communicated the same judgment to the concerned authority.
Yes. Then
And then the impugned order has been passed and inflicted the punishment of postobus of 1 increment. And in this regard, the Honorable Apex Court in a
wait, take us to the order of punishment.
page 80.
Yes.
Whereas a departmental proceeding was drawn up against so and so of police CID Assam Ulubari Guwahati and shows proposed notice was issued to him by memo number so and so dated 25/7/2018 for a serious misconduct, and whereas Inspector so and so submitted his written statement in defense by his letter dated so and so wherein he denied the charges. Whereas having not been satisfied with the reply to the chocos notice submitted by the charge officer, Inspector so and so, it was decided to get the charge inquired into by the inquiry officer. And whereas Sri so and so, Additional Superintendent of Police Kokrajhar, Assam was appointed as inquiry officer to hold an inquiry into the charge framed against the Inspector so and so, and Sri Makhan Bara APS, Deputy Superintendent of Police, Boingao, Assam, was appointed as the presenting officer of the departmental proceeding by memo number so and so. Whereas the inquiry officer Sri so and so submitted his findings dated 35/2019, wherein the charges of the serious misconduct against the Inspector Zamiul Islam is proved beyond reasonable doubt. And whereas a copy of the findings of inquiry was furnished to the charge officer Inspector so and so, and dated 10/6/2019. Whereas Inspector so-and-so submitted his written representation dated so-and-so. Whereas I, being the disciplinary authority, have perused the findings submitted by the inquiry officer, including all relevant records of departmental proceeding file. The charge relates that while Siri so-and-so was posted in KD Lubari, Guwahati as Inspector of Police on the night of 13/5/2018, he along with his family went to the house of Anjali Karzi, wife of Hitesh Das of Village so-and-so. Chirang posted at the account branch office of the Superintendent of Police Chirang. He again went to her house on 14/5/2018 at 8 p.m. alone and tried to kiss her forcefully and asked her to go to bed with him, to which she objected. As she was 6 months so-and-so, and knowingly the fact, he said that she looked very pretty even in the pregnancy and asked her to shut the door. He has been trying to make the physical relationship with her against her will since the days while he was posted as Reserve Officer, Police Reserve Tirang, so-and-so. In this regard, so-and-so lodged an FIR against him, which was registered by Taligaon PS case number so-and-so. He was arrested and forwarded to the judicial custody was 17/5/2018. Therefore, he was charged with the serious misconduct. During inquiry, the inquiry officer found the charge of the serious misconduct against Inspector Jamul Islam is proved. I agree to the findings of the inquiry officer that the charges of serious misconduct against the search officer Inspector so-and-so is proved. I have also perused the representation dated so-and-so submitted by the search officer Inspector so-and-so. The search officer has not brought any new fact in his representation. Hence, after careful consideration of all the documents record, including the written submission of the delinquent officer and application of mine, I hereby impose the punishment established of 1 increment with cumulative effect upon the delinquent officer. He is released from the suspension with effect from the period of suspension so-and-so, excluding the period of judicial custody, is created as a duty. The period of judicial custody, which is 17/5/2018 to 25/5/2018, is stated as diagonal on the principle of the no work, no pay. The departmental proceeding is disposed of accordingly. Then the appeal has been filed. The appellate authority has upheld the order of the departmental proceeding. The order is appellate authority order is page 91. And in the show cause notice, my lord, the lordship has found the allegation, the statement of allegation. Is the copy of the FIR.
Is it clear acquittal or benefit of doubt?
Clear acquittal.
No, but final order says clear acquittal, but the discussion is benefit of doubt.
But in the final order, my lord, is clear.
No, but you have to read the entire
Even-
order.
Even, my lord, they could not establish to present the petitioner in the place of occurrence.
Kindly come to page 74, read that
Yes,
paragraph.
yes. Clear doubt as sin for could not establish regarding the presence of the accused
Yes,
without any iota of doubt.
without
Then-
any iota of doubt.
No, then come down.
Further, there is a doubt emerged out regarding the veracity of evidence of the so-and-so locals and Recuna in the story of the prosecution and
Read the last line.
the it creates the serious doubt regarding the story of the prosecution. And in the criminal law, the doubt always give benefit to the accused person. But my lord, doubt regarding the stated here in the judgment, my lord, that they could not even establish the presence of the petitioner in the place of occurrence.
We don't know. We are not in appeal against the judgment. What we want to say is that where there is a clear acquittal, there is no evidence.
Yes.
Here is a case, there are loopholes, these, that, so there is a doubt. So because of this doubt, benefit has to go to the accused. So that
But
in my understanding is not clear acquittal.
But
You have been given an acquittal, but on the benefit of doubt.
Benefit of doubt.
So under such circumstances, whether there is yes, you are relying on GM time,
yes,
but there are subsequent judgments also. Have you brought it out? There are subsequent judgments
In fact, the list of witnesses, lordship, those who are being cross-examined,
Hmm.
in the departmental lordship proceeding, there were 2 witnesses extra which were not being cross-examined by the court, lordship. That is one Yuvras IPS of SP
Yes.
and
See,
Pavindra
in
Kumar.
Tang, it was honorable acquittal,
Yes.
honorably acquitted.
But in the relevant witnesses are same, my lord.
No, the principle is that where you are acquitted on all charges honorably, then there's no point in going for departmental proceeding on the same charges, same witnesses. If you do, then you need reasons. Here is a case, in your case, on the facts of it, reading the order, it appears to be benefit of doubt.
But one thing is very clear from the judgment, my lord. The presence of the petitioner in the place of occurrence, they could not establish. That's very clear. If the presence of petitioner would not have been established by the prosecution, my lord,
But then
Then-
the departmental proceeding will not, the test of proof in evidence is slightly different.
but all the evidences are contradictory. My lord.
But having said that, Mr. Sharma, the authority did not even refer to the criminal
Yes.
case. They did not even refer. Was it not in their knowledge? How could it be?
No, it cannot be.
No,
They should have referred.
Definitely.
They should have referred. They should have said that, yes, this judgment although has given, but these are the grounds on which
Excellent. As
we
per
have gone ahead with.
and that judgment has already intimated to them.
Hmm?
Before passing the impugn order, my lord, that judgment has already been intimated by the petitioner.
Yes. What do you say?
let's say I'm comparing the evidences of both the of the in the criminal proceeding, lordship, and in the dependent proceeding. Lordship may kindly see the examination of witness Sri Yuvras IPS SP, lordship, Dhubri. He was not as in the list of witness before the lordship court, the judicial magistrate, lordship. That is at page number 68 of the lordship affidavit filed by respondent number 4, lordship. Which says that he stated that on 15/5/2018, while he was posted at Sirang district as the SP Sirang, he had received a complaint from the WHG, which is Anjali Kari office, and the same was forwarded to him to the OC Dhaligaon for registration of a case and for taking necessary.
Page number,
Running test number 68, lordship.
68. First paragraph.
Yes, examination of witness of C. Yuvras, IPS SP, Dhubri. Third lordship, found lordship.
'68 is
It's a part of the lordship inquiry report of Annexure F.
no. 68 is a part of the judgment in this copy. 68 is called
Annexure F of the affidavit in opposition, lordship.
affidavit in opposition.
Of respondent number 4. Second, in the inquiry report, lordship, second page is the list of witnesses.
Affidavit, I have found it, but paragraph number?
It is paragraph number 2.
Yes. Read?
Examination of witness, lordship.
No. I'm reading from the affidavit.
Yes, affidavit in opposition, Annexure F is the inquiry report.
No. We have an affidavit in opposition filed by respondent 4 on
Yes.
11 November.
But yes,
Yes.
11 November.
that was I have. Fine, my lord, but the-
Annexure F is the inquiry report, lordship.
There's no annexure.
No
here.
annexure,
There's only one annexure order,
only order,
4th September.
4 September 2020.
That is the only order.
Nine, okay, nine. Okay.
Then there's an affidavit in reply.
Yes.
That's all.
Then it will be difficult, Lordship, because if it is not a part of record.
We don't know, it is not there.
No copy has been served to me also.
Has it
I
been
think
filed?
That has
this
not been
inquiry
filed.
report, I think the inquiry report has also been attached with the
Yes.
petition, Lordship.
Yes.
Yes. Inquiry report is there. But have
I'll
you, has
read
the
from-
affidavit been filed?
Yes,
That-
Lordship, the one copy of the affidavit is here, Lordship.
No copy is there, but are you sure it has been filed?
No, one affidavit, so it is shown that one affidavit is filed on
Yes.
18/11/21.
So 1811 is.
And I cannot say that this, this particular Lordship, this annexure, whether it is attached with that affidavit or not. That
No, it
was
is not
also
there.
involved in
It is
file.
not there. You have a look.
There is one affidavit and file.
There is one affidavit of respondent 4, which is filed on 11 November.
11/11 to
And it has got only one annexure, which is the order dated 4th of September. You verify the records if you have filed it.
I have to check, Lordship. Otherwise, Lordship, may kindly see from the writ petition.
Yes, is that particular document available in the
Yes,
writ petition?
Yes, it is there, Lordship.
Then it is okay.
Here it is annexure 7, Lordship. That starts from page number 44 of the writ petition. Page number 45 is the list of witnesses, Lordship.
Yes.
This one list of witness number 1 and 2. Page number 46 are the examination of witness of Sri Yuvraj. Because these witnesses were not been, I have checked, Lordship. I think they were not been examined before the criminal proceeding, Lordship, before the magistrate. This Yuvraj SP. He stated that on 15/5/2018, while he was posted as Sirang district at the SP Sirang, he had received a complaint from the WEG Mrs. Anjali Kade office, and the same was forwarded to him of the OC Talika for registration of the case and for taking necessary action. Thereafter, he informed the matter to his senior officer over telephone and detailed the party at CID headquarters to bring the delinquent inspector Jamil Islam, and in this regard, a delinquent report was also submitted by him to the Superintendent of Police, Guwahati so-and-so, as well as the ADGP, Guwahati. Further, he stated he had submitted draft search statement of allegation against Jamil Islam of CID organization as per direction of the ADGP, white memo so-and-so. Also, then examination of Povindra Kumar Nath, SP. He stated that on 17/5/2018, a WT message so-and-so were received by him from the OC Dhaligaon PS, intimating that Inspector Jamil Islam of CID was arrested and forwarded into judicial custody on so-and-so. On receipt of the information, the matter was put up before the Special DGP CID Assam, and as per direction of the Special DGP Assam, a report was submitted to the ADGP Assam, Guwahati white memo so-and-so dated, intimating about the arrest of delinquent inspector Jamil Islam in connection with the above referred case. Subsequently on so-and-so, a detailed report was submitted to the ADGP Assam white. From his end in connection with the case, he also stated that Inspector Jamil Islam CID organization was deported to South Salmada on so-and-so for investigation of CID PS case number, along with Sri Satho Kai Sangsan IPS, who Assam, who was also deported to investigate by proving a government vehicle for the same. After completion of the investigation, Deputy SP returned from South Salma after 3 or 4 days, but the Inspector Jamil Islam did not accompany with the Deputy SP Assam during the return journey after completion of the investigation in South Salma University. So the lawsuit, page number 49 is lawsuit. Fact as revealed during the inquiry, lawsuit, page 49. Let's just read out lawsuit. During inquiry of the DP drawn up against Inspector Jamil Islam of CID organization, as many as 6 witnesses were examined and their statements were recorded in writing. Moreover, documentary evidence such as copy of detailed report by memo number so-and-so data of the SP Sirang Kaling Kajalgaon, copy of memo number so-and-so of the SP Assam Ulubari, Guwahati, and copy of FIR details was submitted by WHG Anjali Kari, wife of Hitesh Das of Sirang. The following facts have been come out in the light after going to the statement of prosecution witness and aforesaid documents as well as relevant documents which are mentioned below. The delinquent, Jamil Islam of CID organization was deputed to South Samaration for investigation in connection with CID PS case number 9 of 18, along with Sri Sap Pokai Sangsan APS of Superior Police CID, who was deputed to investigate the CID PS case number 8 of 19 by providing a government vehicle. But Sri Sat Pokai
It's
Sangsan
the same
APS
allegation.
Same.
It's the same allegation. It's not that it has brought out something more which was not covered by the,
in the conclusion, it has been stated the misconduct has been found that is beyond reasonable doubt.
what misconduct? What is the misconduct?
Misconduct of
Misconduct
lawsuit-
is of visiting that woman constable and making overtures. That has been held to be not proved because of lack of proper evidence. Now,
examination-
on the same grounds, it is not a case of supposing, let us say, let us give you a food for thought. See, if you look into the examination of page number 46, examination of Povindra Kumar Nath.
Lordship.
So here on the next page, you find that he has accompanied Deputy SP,
Lordship,
CID,
to the place.
to the place,
Yes.
who returned after 3-4
Yes.
days. But he did not accompany. He did not come back.
Yes. He
The
remained there.
delinquent officer did not
He-
come
he
back.
remained
They
there.
went together, but only the SP returned, delinquent officer did not come back. Now
So
it is
that is the actually benefit of doubt.
what that is actually. It is not your proceeding. You are not proceeding against the officer for dereliction of duty. Perhaps you could have proceeded against him saying that no, you should have returned on the same day because you have gone for investigation. Not returning is a dereliction of duty. It is not the ground on which the DP has been initiated. You are presuming that he stayed for 3-4 days. That means he is
Yes,
guilty.
something has happened.
Something else. That is entirely wild card entry. The allegations are one and the same entirely. Yes. Now you are relying on.
GM tank, my lord.
But there are subsequent judgments, I told you.
2022.
I don't know. That's for you to find out. What are the facts involved here?
But the error regarding a rate has been made by the inquiry officer for gratification. my lord. In this case, in GM tank. Para 20 and 30. my lord.
We have a copy.
Yes.
We have a
Oh,
copy.
yeah.
Yeah.
Para 20. my lord. It is the sin that this is a case of no evidence. There is no iota of evidence against the appellant to hold that appellant is guilty of having the illegally accumulated excess income by way of gratification. The respondent failed to prove the charges level against the appellant. It is not in dispute that the appellant, being a public servant, used to submit his yearly property return relating to his movable and immovable property. And the appellant has also submitted his return in the year 1975, showing his entire movable and immovable assets. No query whatsoever was ever raised about the movable and immovable assets of the appellant. In fact, respondent did not produce any evidence in support or about the LS charges level against the appellant. Likewise, the criminal proceeding were initiated against the appellant for the LS charges punishable under the provisions of the PC Act on the same set of facts and evidence. It was submitted that the departmental proceeding and the criminal case are based on identical and similar set of facts and evidence. The appellant has been honorably acquitted by the competent court on the same set of facts, evidence and witnesses, and therefore the dismissal order based on the same set of facts and evidence on the departmental side is liable to be set aside in the interest of justice. And the para 30, my lord, the judgment relied on by the learned counsel appearing for the responder distinguishable on the facts and law. In this case, the departmental proceeding and the criminal case are based on identical and similar set of facts. And the charges in a departmental case against the appellant and the charges before the criminal court are one and the same. It is true that the nature of the charge in the departmental proceeding and in the criminal case is different. The nature of the case launched against the appellant on the basis of the evidence and the materials collected against him during inquiry and investigation, and as reflected in the charge sheet, factors mentioned are one and the same. In other words, charges, evidence, witnesses, and circumstances are one and the same. In the present case, criminal and departmental proceeding have already noticed or granted on the same set of facts, namely raid conducted, the appellant's residence, recovery of the articles. Therefore, the investigating officer, Mr. So-and-so, and other departmental witnesses were the only witnesses examined by the inquiry officer, who, by relying upon their statement, came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, and the criminal court on the examination came to the conclusion that the prosecution has not proved the guilt alleged against the appellant beyond any reasonable doubt, and acquitted the appellant by judicial pronouncement with the finding that the charge has not been proved. It is also to be noticed that the judicial pronouncement was made after a regular trial and on hot contest. Under this circumstance, it would be unjust and unfair and rather oppressive to allow the findings recorded in the department proceeding to this standard. In the Paul Anthony case, my lord, also this same finding. My lord.
Yes,
Lordship, there is a judgment, Lordship. We have found, Lordship, that Allahabad Bank versus Krishna Nayan Tiwari of Supreme Court, Lordship, civil appeal number 7600 of 2014. May I just read out, Lordship, or Lordship is willing to say from here?
you read out.
You
Give us the citation.
Lordship, it is civil appeal number 7600 of 2014, Lordship.
Seven six
00
Hmm.
of 2014.
date.
The parties name are Allahabad Bank versus Krishna Nayan Tiwari. Lordship,
What is the date of the order?
order date is, Lordship. Yes. 2nd January 2017. 2nd January 2017.
Yes.
It's read as under, Lordship. In this appeal by special leave, the appellant calls in question the correctness of a judgment and order passed by High Court of Judicia at Allahabad Lucknow bench, whereby writ petition so-and-so filed by the respondent has been allowed and an order is passed by the disciplinary authority, and that passed by the appellate authority directing removal of the respondent from the service of the appellant bank was. The High Court, as a result, directed the appellant bank to provide all service detailed benefits to the petitioner with 90 days of the order. The challenge mounted by the appellant arises in the following circumstances. The respondent was employed with the Allahabad Bank and was during the relevant period posted as officer in charge at the Allahabad Bank Sultanpur branch in district Sultanpur in the state of Uttar Pradesh. He was by an order dated 10 December 2004 placed under the suspension in contemplation of a disciplinary inquiry which was initiated against him with the service of charge sheet dated 10 February 2005. The respondent pleaded not guilty, by the inquiry officer concluded the inquiry proceeding rather quickly within a span of just about 45 days and submitted a report dated 27 May 2005, holding that the respondent was guilty on all counts except two which were held proof, but only partially. The respondent authority accept the findings and pass an order imposing upon the respondent a major penalty of removal from service. Aggrieved, the respondent preferred a departmental appeal which was dismissed by the appellate authority by the order, so into the respondent and present the said two orders before the High Court in a writ petition, which was noticed earlier and has been allowed by the High Court in terms of order, including this appeal. The High Court came to conclusion that neither the disciplinary authority nor the appellate authority had applied their mind or the recorded reasons in support of their conclusion. Then proceed on behalf of the appellant bank, it was contended before us that High Court had exceeded its jurisdiction in re-appreciating the evidence and holding the respondent not guilty. It was argued that so long as there was some evidence on which disciplinary authority could raise this finding, sufficiency or insufficiency of such evidence could not gone into by writ court. Alternatively, it was submitted that even if there was an infirmity in the orders passed by the disciplinary authority or the appellate authority on account of absence or insufficiency of the reasons in support of the finding recorded by them, the proper course of the High Court was to remand the matter back to the appellate authority or the disciplinary authority as the case may be for doing the needful affairs. The High Court could not, on account of absence of reasons of unsatisfactory appraisal of the evidence by them, quash the order of punishment and direct release of the service benefits due to respondent.
You give us a list of your judgments. We'll
Lordship.
follow it up. We'll take it up on Thursday again for further hearing on Thursday. After GM tank, there are a few judgments you can go through and apprise the court. But prima facie, there is no new evidence.
Yes.
There is no new evidence.
These two
You did not go into any other area. You did not even refer to the criminal court judgment, which again prima facie gives a finding that you are hell bent on punishing him. Prima facie. List on Thursday for further hearing.
Please, your lordship. Lordship. Matter relates to compassionate appointment method. And the petitioner's father died in harness on 3/8/2009. And my lord, on the earlier round of litigation, my lord, this court, my lord, directed the respondent to reconsider the claim of the petitioner, recommending his case against the vacancies which were arose in the year, my lord, 2009 and 10. Now, my lord, I would like to point out one affidavit filed by the respondent number 5,
Who is respondent 5?
Deputy Commissioner.
What is it? What does it say?
My lord, in this affidavit in opposition, my lord, I would like to point out, my lord, page number, my lord, 6, page number 6.
Hmm.
My lord, while the DLC commands the case of the petitioner, my lord, there was a post, my lord, available. 2009 and 10 column.
Hmm. Yes.
Here it reflects one vacancy available under the compassionate ground. DLC commanded the case of the petitioner.
Where is your application?
Application, my lord, affidavit in opposition filed by the respondent number 4. Annexure B, my lord, page number 6. My application.
Annexure
Annexure B, my lord.
of
Affidavit filed by the respondent number 4, my lord. They have any.
respondent 4.
Yes. Ma'am. Executive engineer PhD, my lord.
Is not here. Respondent 4 affidavit is not here. We will not accept copies like this because it is a court file. If it is file, it has to be enclosed to the court file. Has anyone filed
It was
affidavit?
there, my lord, on the
Lordship.
earlier occasion.
Lordship, is the department, Lordship. Before going to that point, Lordship, I would like to submit before this honorable court is that, Lordship. The grievances of the petitioner is the minute dated 14/5/2020, Lordship. It was passed by the SLC, Lordship. But the SLC is not the party here in this case, Lordship, first of all. And second, Lordship, in the prayer of the petitioner, Lordship, there is no specific prayer for set aside the impugned minute, Lordship. Therefore, Lordship, this petition is not accordingly placed, Lordship. Therefore, it may be dismissed, Lordship. The primary grievances is not addressed here in this case, Lordship. Neither he made the party to the SLC, and that the set aside of the minute dated 14/5/2020 is not the prayer of the petitioner, Lordship.
Yes,
Yes, my lord.
Your
Yes, my
case
lord,
is
it was in
rejected by
prayer.
the SLC.
Yes, yes.
You not challenge that.
I may be allowed to make them a party. He was- I may be allowed to make.
Making a party will not help. You have to challenge it. You have to challenge that
Therefore,
order.
he should file another petition, Lordship. This is the Vegas petition.
You should have challenged it.
In the entire petition, Lordship.
Ultimately, your case was rejected by the SLC.
Yes,
That order is not under challenge.
yes, Lord.
That is under.
And
challenge.
it is, Lordship, it was not addressed in the petition, Lordship. The contents of the petition is not addressed.
No, it is there, para 7. Reference to the order is there, but is not challenged.
Yes, Lord. It is not challenged.
Is that order available on record?
My lord, writ petition number 2222 order is there.
SLC order.
SLC order is there, my lord. 14/5/22, page 18.
It is here.
Page 18. Column number 1.
What is your case? It has been rejected on the ground of lack of.
They have recommended my case, my lord, against the vacancy which were arose in the year, my lord, 2015.
2015.
Yes, ma'am. But
Where?
DLC have recommended my.
Where? Which page?
My lord, column number 1, ma'am. Page 18, ma'am.
Page 18. Page 18 is that the minutes of the
19.
SLC.
Page 19, SLC, ma'am. Yes.
Then
Page 19, my lord.
paragraph.
From second para, my lord, in para number 5 of the OM states that compassion and appointment is not the matter of light and it will be subject to fulfillment of all the conditions.
Where is your case recommended?
My lord, here it says, my lord, 10 vacancies are to be filled by the way of direct recruitment, my lord. Here, they haven't mentioned it, my lord, but they have recommended the case, my lord, 2015 vacancy.
Who has recommended?
SLC.
SLC.
SLC money rejected, my lord, placing the case of the petitioner against the vacancies of 2015.
What is the state of the DLC?
DLC has recommended the case.
Where is that DLC recommendation?
DLC recommendation I have, my lord, here, my lord, affidavit in opposition filed by the respondent number 5. Recommendation is DLC, my lord. Page 6. Page 6, my lord, column number 1. Last.
What is your name?
Komal Baramel.
Yes.
Recommended for the year 2009 and 10.
Hmm.
There was a vacancy ma'am, at that point.
For
of
the
time.
post of driver.
Yes, ma'am.
This was the minutes in which date?
Minutes dated, my lord,
2013.
2013.
Hmm. Then
Thereafter, my lord.
it was recommended by the SLC.
Yes, again, placed before the SLC, my lord. on
Where is the
21
where is the rejection?
21/11/2015. On 21/11/2015, they rejected the claim. of
Yes,
the-
Mr. Goswami. SLC rejected it on the ground that it does not fall on the 5% kicker.
Yes, Lordship.
But DLC has recommended it. So there has to be some reference at least.
Yes, Lordship. There may be, Lordship, but first he should
Don't be
make
so
the party,
technical.
Lordship.
Don't be so technical. It
Yes,
is
Lord.
there, the minutes are there.
But Lordship, regarding the SLC regarding the SLC rejection, Lordship.
Page
it is-
21, 21A.
Yes, 21A, column 10, Lordship.
Yes. It's been rejected
Yes.
on the
it
ground
was
that it does not
rejected.
fall under 5%.
Yes, Lordship.
Now,
so-
there has to be some reference as to the
Yes.
recommendations of the DLC.
It may be.
My lord, I would like to point out one more thing, my lord. On the earlier round of litigation, this court, my lord, specifically directed the respondent, my lord, to consider the case of the petitioner against the vacancies of 2009 and 10, my lord. Page number 17. Page number 17 of the petition. This direction was issued by the, my lord, this honorable court on 11/4/2018.
Which vacancy is challenged here? Which order is challenged here?
My lord, minutes dated 14/5/2020, my lord. Page number 18.
No, in page number 16.
Page number 16, my lord.
SLC
minutes
meeting,
dated
21/11/2015
was challenged.
You get the instructions, not clear your affidavit. Somebody from SLC will have to get instructions here. There is a specific direction. Page number 17.
Yes, Lordship. Page number 17 is there, Lordship.
Yes. It says consider in respect of 9 and 10.
But at the same time, Lordship, the issue notice to the SLC is required, Lordship.
Why? Why?
Because SLC is not the party here, Lordship.
So
At the same time, Lordship, the prayer of the petitioner
it
is
is
not
for
there.
us to decide who should be party, who should be not. If you are aggrieved, you go and file an appeal.
Lordship.
We are asking you to get the instructions. Who is the chairman of the SLC?
It's Chief Secretary, Lordship.
Then why should the chief secretary be put to notice? We just need to know whether the order of the High Court has been carried on. You get the records
Regarding this order, Lordship.
regarding the
70
rejection of the case in the 2020 order, read
Lordship.
with the earlier order passed by the High Court.
Lordship.
High Court has directed that you have to consider against the vacancy of 2009 and 10.
Lordship.
Rejection order does not reflect anything.
Lordship.
So are you not able to give us these instructions without arraying them as parties?
Lordship.
If you want, we will record it.
No, Lordship.
That we did not want the chief secretary to be
Lordship,
arrayed as a
I
party,
will
but
come-
the
Lordship,
insistence of the
I-
common
I-
council, we are erring as a part.
I will
Then-
submit accordingly
Yes.
as per the direction of the court.
When will you get the ST instructions?
Lordship,
Limited instructions,
next
whether
week, Lordship,
SLC, while rejecting this case in the 2020 order,
next week, Lordship.
took note of the directions of the High Court to consider his case in 9 and 10 vacancy. That's all. And what reference to the recommendation of the DLC.
Lordship, beside Lordship, this matter was discussed in the Annex C 18, page number 18, Lordship.
Yes.
I think a contempt case was there. A contempt case was there.
Contempt was closed. my
No,
lord,
no, but
because-
a contempt was there, but here it refers, Lordship.
Contempt was
based on-
there perhaps because the matter was not considered by
Lordship.
SLC.
Lordship,
Subsequently, it considered and rejected,
Lordship,
but in the order of rejection, there is no reflection.
Lordship,
So it must be available in some file,
Lordship,
minutes,
Lordship.
details.
It may be, Lordship.
Yes. Third learned counsel for the parties, Mr. J.K. Goswami, learned counsel appearing, additional government advocate appearing for the state, will place before the court the relevant records which will reflect whether the SLC, while rejecting the case of the petitioner by its meeting held on 14/05/2020 within bracket Annexure C, took into consideration the directions of the court passed in WPC number. Where is that order? 22222 of 2016,
16.
dated 11/4/2018, whereby the coordinate bench of this court remanded the matter back to the SLC to consider the case of the petitioner against vacancies of 2009-2010 as recommended by the DLC. Stop. Para. The minutes of the meeting, para. The DLC by its meeting held on 25/11/2013 recommended the petitioner for the post of driver. Under the office of the executive engineer, PHE, Jorhat Division, Jorhat. The recommendation was for the year 2009 and 10. Vacancies for the post of a driver, one vacancy for the post of a driver was shown to be available. Stop. Para, the minutes of the meeting held on 14/5/2020 shows that the petitioner's case was rejected due to non-availability, shown to be rejected as it was rejected as it was shown that it did not fall under the 5% cadre strength. Did not fall up to cadre strength within quotes or italics. Stop. The minutes, however, does not reflect as to how the recommendation of the DLC was considered by the SLC or the directions of the court passed in by the order dated so and so in WPC so and so. Stop. These instructions will be placed by the learned government advocate on the next date fixed, placed on 11 October.
I'm highly obliged. my lord. Highly obliged.
Second appeal.
there is pending second appeal. I filed the petition.
We'll dismiss it.
Lordships.
We'll dismiss
actually,
it. You go and contest the second appeal.
I already filed lordships, but second case is also maybe dismissed lordship because civil suit in the already set aside the appointment. She stated she was not being heard. He contested the
Who
case.
filed the other writ petition?
Other file by respondent number
Why?
6.
Lordship, in the meantime, she was discharged from service, Lordship. So I have challenged that order. Accordingly, it was.
But that is
stayed.
pursuant to the order of the
No, Lordship.
Yes.
court.
No, Lordship, there was no such direction given by, or there was no such Lordship step taken by the petitioner for execution. So Lordship, without any instruction, Lordship, they cannot discharge the petitioner from the service, Lordship. So the Honorable High Court already stated that matter, Lordship. And in that case, Lordship, we have taken step on last week, Lordship. They did not appear in that case, Lordship.
I filed Vokalat number Lordship. Our today I have filed. And in this case, Lordship, second case, because in terms of the direction of the title suit, her appointment was set. And trial court also said that appointment is set aside and cancelled. Respondent authority government taken steps, Lordship. For execution of the
Sorry,
order of
sorry.
the court. And here is the case, learned.
You go and approach the civil court.
Yes, I approached the civil court.
No, for execution.
For execution, Lordship, there is no provisions. I didn't find any
You-
provision regarding
No,
order
you-
21 rule 6.
You go and file, let us see what orders are
Lordship,
passed.
even in the
Let us see what
application-
orders are passed. Why have we not approached? Why have we not filed?
no, Lordship, what to be stated in the execution.
No, we
petition
don't know
is
that.
Elaborately stated in this in the CPC, Lordship. There is no, I did not find any provision to regarding my claim, Lordship. In an exceptional case, Honorable Apex Court state that.
You show us an authority that in a case like this, that there is no provision for
Lordship,
filing
in
an
the CPC
execution.
shows, Lordship. CPC shows.
No,
order
you show,
21.
CPC shows, but you show us on what basis you are making this. Your first approach should have been to go and approach the civil court.
Lordship.
If the
But
civil
what
court,
are the-
if the civil court passed an order saying that, sorry, we cannot issue orders under an execution suit, I can understand you have approached this court.
Yeah, order 21.
This is
rule
your
shows-
interpretation.
Yes, Lordship, order 21, rule 10 says, Lordship.
No,
what are to be
we
stated in the
refuse to accept,
application.
we refuse to accept, we are dismissing it. Or you'd like to support your
Lordship,
contention
in my
with the judgment.
application, I have to, if I filed an application before the civil court for execution, that part are to be stated that,
Okay, hard
Are-
learned counsel for the parties.
that
This writ petition is filed by the petitioner, praying for a direction. What are your prayers?
a prayer is to make an advertisement by and cancelling the appointment. In the meantime, appointment has been cancelled by the respondent authority.
Praying
and
for
the
a writ
government.
of certiorari for setting aside and quashing the appointment of private respondent number 6 at Anganwadi Center, number 98 of Dasgram Village, Ward number 6, attached with Dasgram Model LP School. Stop. Initially you were appointed.
No. Without respondent authority, without following advertisement.
It is
appointed.
submitted that without following the proper procedure, the respondent number 6 was appointed at the so-and-so Anganwadi Center. Being aggrieved, the petitioner filed a suit being titled suit number 127 of 2011 before the learned court of Munsif, number 1, Karimganj. Stop. The suit was decreed in favor of the petitioner and the appointment was set aside. Appointment was set aside.
Yes.
Stop. However, the petitioner, in spite of being the decree holder, did not proceed for execution of the suit.
Lordship may kindly see page 42 and 43, the exact words are for liable to be cancelled. This is the decree, Your Lordship.
42 and 43.
Yes, Lordship. Type copy of the decree, Lordship.
You right, in the decree, the trial court, learned trial court, held as under page number 43 strict. In spite of the judgment and decree being passed in favor of the petitioner did not proceed to execute the decree. Stop. Meanwhile, an title appeal was filed by the private respondent, being, what is the number of title appeal?
12 oblique 2020. Title appeal number 12 of
12 of
2020.
2020. Stop. This title appeal ultimately came to be dismissed. Dismissed
Dismissed.
Condonation was rejected, Lordship.
on the ground of delay, as the application for condonation was not allowed.
Accordingly, title appeal was also dismissed.
Stop. Aggrieved, the private respondent has filed a second appeal before this court, and which is slated to be pending. There is also a delay here.
No, Lordship.
No delay.
Within time. One IA
second
was
appeal.
for stay.
Second appeal is admitted.
Yes, Lordship.
Then the
My
same is
additional-
admitted as submitted by the counsels for the bar. Stop. The writ petition is filed on the ground that there is no alternative remedy available prescribed under the CPC for execution of the decree as passed by the learned trial court. Stop. Mr. So-and-so learned counsel for the petitioner has referred to the provisions of CPC in support of his claim. Stop. Learned counsel appearing for the respondent disputes the claim of the parties, the petitioner, and submits that no direction can be issued as prayed for, in as much as the there is already an order of the civil court passed in title suit number so and so, and a second appeal arising out of the said matter is presently pending before appropriate bench in this high court. Stop. Para, having heard learned counsel for the parties, this court is carefully perused the pleadings on record. It is seen that the title suit has been prepared by the petitioner, challenging the appointment of the private respondent. The suit was decreed in favor of the petitioner. Against the said judgment and decree, a title appeal was preferred by the private respondent, which came to be rejected as the delay was not condoned by the appellate court, first appellate court. Stop. Against this order, matter is presently pending before this court in a second appeal. Stop. It is submitted by the learned counsel for the parties that second appeal has already been admitted for hearing. Stop. The submissions of the learned counsel for the petitioner that there is no remedy available under CPC cannot be accepted in as much as by order dated so and so the judgment was delivered and the suit was decreed. However, the petitioner, for reasons best known to him, abstained from proceeding for execution of the said suit. Stop. The CPC is a complete code in itself. It has laid down effective orders and rules for grant of effective and specific reliefs to the litigants. Stop. No approach has been made by the petitioner for, no steps have been taken by the petitioner for execution of the suit. Stop. No order of the learned court below, learned trial court, has been placed before the court to show that the application for execution was rejected or orders were refused to be passed. Stop. The issues raised in this writ petition concerns number of facts which were determined on the basis of evidences adduced by the civil court. Stop. Ordinarily, when there's an alternative remedy available, exhaustive alternative remedy available under the CPC, the writ court would not like to exercise its jurisdiction entertaining writ petitions. Stop. In exceptional cases where it has been shown that no such remedy exists, there may be a case where a writ court may exercise its jurisdiction, even in respect of matters raising disputed questions of facts. Stop. Such is not the situation in the present case. Stop. Learned counsel has not been able to satisfy this court in respect of the steps which he has failed to take for execution of the decree which was granted in its favor by the learned trial court. In so-and-so versus so-and-so, the apex court held as under will. Now, in that, in a perusal of the pleadings on record and taking note of the law laid down by the courts, this court is of the view that where efficacious alternative remedy is available and the litigant before the court, he has not proceeded to avail of such a remedy without justifiable reasons, a writ court would be justified in turning down the plea of the litigant. In view of the discussions held above, the writ petition stands dismissed. In terms of the above, no order is to post. Yes.
One case lost in 1990, AIR 19 Supreme Court, Supreme Court 2251 said that in an exceptional case, one line may hang.
You give it to us, we'll put it in the order. Yes. Mr. So-and-so has referred to, what is that citation?
Citation AIR 1991. Supreme Court.
When you are making an
2251.
argument, you are supposed to support it with orders.
In exceptional case.
No, correct. But when we asked you, you did not produce the judgment.
Lordships, I did not take a chance to play.
You did not take a chance. How
I
nice.
am
Yes, yes.
making submit the Supreme Court said. Yeah. Paragraph 8, Lordships. Paragraph 8.
Yes,
last-
para 8.
Para 8, last page for of Lordship, middle part, your Lordship will
Yes.
find.
Hmm.
After referring the so-and-so cases, Lordship, so far the questions, Lordship, got it?
Para 8.
Para 8,
Ah,
next page,
next page.
middle part,
Yes.
referring some of the cases of 1975 Supreme Court, then after 2 lines, so far.
It is 20.
Lordship got it?
So
Right.
far.
So far.
Yes, so far.
So far, the question of executability of a decree is concerned.
Hmm.
The Civil Procedure Code contains elaborate and exhaustive provisions for dealing with it in all its aspects. The numerous rules of Order 21 of the court take care of different situations, providing effective remedies not only to judgment debtors and decree holders, but also to claimant objectors, as the case may be. Next line.
This is what we had
In an
quoted.
exceptional case.
This is what we had quoted.
Yes, already quoted. That's why the Lordship may refer in this line.
You are referring to this Ghanasham Das Gupta.
Yes,
Huh?
yes.
Yes, yes.
And next case, Lordship, my learned file. The
We have already dictated the order now. Why are you
Another
referring to the
case.
cases?
On the next case, Lordship not taken care of.
Ah,
Two cases listed.
yes, yes.
In
Next
that
case we
case,
take
my
care.
learned authority has cancelled the appointment of the private responsibility.
In that
She
case,
challenged.
Lordship, today
Yes,
maybe he have filed wakalatnama, Lordship. I'm
And-
not aware about.
What her rights, Lordship, because without following any procedure by backdoor policy.
You file your objections, we'll file your objections, we'll hear it. Notice has been issued here.
Yes, Lordship.
You file your objection
Lordship.
or affidavit
Lordship.
in WPC 2276. Mr. F.U. Barbuya submits that you'd like to file affidavit and is received instructions to appear in the matter.
Lordship.
Accordingly, matter stands adjourned for how much time do you require?
3 weeks,
3 weeks.
November.
He is for respondent number 5, Lordship, here in this case, and government respondent also not filed any.
Government respondent will say suit is pending. What else are they supposed to do? Prays for and is granted 3 weeks time to file the affidavit.
Prior to vacation, Lordship, 2 weeks. Prior to.
All right, 2 weeks to file an affidavit. Similar prayer is also made by learned senior government advocate.
Lordship, in other one, Lordship, I am also appearing for the state respondent.
Yes.
Item 5.
Apply.
Yes, we are sorry to trouble you, but what has happened is that one of your colleagues is in bereavement. So, but government councils, I think you need to make alternative arrangements if the council is not available. Because you see, we are fixing matters.
That is true, Lordship. Unlike the state Lordship, here is with different Lordship.
You find a way, but one
definitely
matter,
I
two
will
matters, all right, but 6, 7 matters
Yes,
on a same day, difficult. And when the interest of the union is involved.
These the
We are adjourning the matters. We are just
I
expressing our concern before you.
I will take it up in a different way, Lordship.
Because, you see, that is the whole purpose why you have a panel. The different difficulties will obviously be there someday or the other.
Yes.
Yes, what is your prayer?
My lord, today, my lord, because of the bereavement, but if your lordship wants to hear, I can.
What is the matter about?
My lord, the petitioner before your lordship was.
Adverse remarks.
Adverse downgrading, my lord. and-
Downgrading.
Yes.
All right.
Can I show one page, lord?
No, we are not hearing the matter in the absence of.
My lord.
Please tell us when do you want to do the matters?
Lordship, so far as Lordship is 23, 20,
No, one and.
1 and 2. 1 and 2, Lordship, if it can be,
We will defer it by 2 weeks, no problem. But
no, Lordship, it can be in the next week.
next week,
Somewhere after 4th,
4th.
after 4th,
All right.
no, 12th October, percent.
10th. You can have it on 10th.
Yeah.
Really not, I can give it to me. That's
10th. A joint request, let matter be listed on 10th. not joint request, the request of the learned counsel for the respondents. Matter stands adjourned. List on 10th. It is submitted that the learned CGC was assigned the matter is in bereavement. Is it necessary or not?
I'll leave it to your lordship.
Cut it off. Request of so-and-so, list on 10th. Yes.
Deeply.
Yes, and there are other matters.
23 lordship, I am appearing for the DRO. When,
But adjournment was sought for, I think.
yes, he is also there part of it.
Then we let the matter be called up. You depute somebody to be present here. One of your colleagues. Let the matters be called up.
Yes. Otherwise, I am here.
I am aware that this is 2013 matter. I am only paying for posting the matter on next week.
Why?
Lordship, arguing counsel A. Sarma, he could not come today, Lordship, due to some difficulty.
What is the issue about? You are for the petitioner.
They have challenged.
You are for whom?
I am for the respondent oil India.
Oil.
We challenge the appointment procedure of Oil India.
Sorry?
We have challenged the appointment procedure. The procedure that was followed by the organization.
Appointment?
Appointment of reservoir engineer in Oil India Limited. We have challenged the whole procedure.
Procedure, okay. What are your grounds for challenge? Are the private parties represented?
They are not represented.
Who are, I think, respondent was 6 and 7 or strike out, Lordship, already.
Struck off.
They are stuck off because they have left the job.
Left the
6 and 7.
Yeah.
6 and 7. Then what about 3, 4 and 5? 3, 4 and 5?
They have not been represented.
Has any notice has been issued?
After 2015, Lordship, the matter was last listed on 2022.
So what remains now to be decided? It's an advertisement of?
For the post of reservoir engineer.
For which year?
2010.
Then what remains here to be decided today?
The petitioner participated.
We had challenged the.
You
whole
challenged it,
procedure.
but
We had challenged the procedure, but the thing is that it got delayed. And in between for 5 to 6 years, the matter was not listed.
it was not listed, but perhaps no mention or.
Not mentioned.
But not necessary that you have to mention. It's a difficulty in the system, but perhaps no attempt was also made to bring it to the notice that this matter needs to be heard and disposed of. So what is to be done today?
So they have sought an adjournment for the day.
No, adjournment is okay, but what remains? That is what we want to find out. What is
The
there?
petitioner has participated. Lordship.
You want the quashing of the entire selection process. Quashing of the entire selection process does not entitle you to be appointed. So
My prayer includes that I should be at least the court should take cognizance of the fact that there has been some procedural lapses in the interview process, and I should get a relief. At least the court should acknowledge and give some direction to the.
what directions you want? That is what we are asking you. Your number 1 says quashing of the entire selection. Then number 2 is issuance of appointment order to the petitioner that can be done.
At present, number 5 can is only viable.
What is there? What
Uh,
orders?
Pass any other suitable order or direction which may.
You,
honorable may-
you formulate what suitable orders you want. Tell us what orders you are asking for. But that will be subject to arriving at a finding that there was some
Lacunae.
lacuna or some fault.
At present, I am established as a entrepreneur.
Then
I
what
am
is the
not
point?
seeking the job or appointment.
Then let us better to close it. Better to close it.
But since I have already challenged the
Mr. Counsel, see, this is not a PIL. You are asking for a relief qua the petitioners. So what is the age for entry today?
27.
27. Entry age. You are 30 on a date you filed it.
Yes, because it took 2 to 3 years for getting all the documents. The process was followed through RTI.
So
We
now
have-
it's more than 10 years now.
Yes.
So there's no scope for you to go back in time and do anything. If you want to agitate this matter before competent authority for any other relief, we can give you that liberty, but your prayers are not capable of being granted today because of efflux of time. And we are also sorry that there was a delay in the matter.
any stricture from the court that
We'll have to arrive at a finding. That
for that
stricture,
matter, I'd like
no,
to
no, Mr.
give a
Counsel,
submission.
that stricture is not applicable to this election. That stricture will not be applicable to any other authorities. Is there any departmental appellate forum?
Whether the department is following still they are carrying on with the same set of norms, same procedure for appointment of reservoir engineers. Whether the court
What
can
was,
give them a guideline.
why were you rejected?
I was rejected
Yes.
on the basis of
Yes, obtain less mark lordship.
Let him submit. Yes.
there are two components in the interview process. One is the written component where 100 marks were allotted.
Hmm.
Another was the viva voce of 100 marks. The written examination was considered as a cutoff and elimination round where only 27 number of candidates were asked to appear for the interview. The interview process again consisted of GD and viva voce. The GD was allotted with 30 marks and 70 marks was allotted for viva voce. In that 70, out of the 70, 20 was allotted for academic credentials, where I passed. I was selected in the written interview, written examination also, and I was called for the interview. After that, I got less marks only in the viva voce, where out of 40, I have secured 19. And in the whole interview process, the cutoff mark was allotted in the written examination. At the same time, in the viva voce also, they have introduced the cutoff mark. Whereas the same set of candidates, they were after elimination round, they were called for the interview. And in the viva voce, they have kept 50% marks as cutoff. And 50% mark was allotted for viva voce, which is more than the norm, that is around 12.5%. That has been Supreme Court has given the direction that around 12.5% of the total mark is to be allotted for viva voce. Because chances of arbitrary allotment of marks is there if it is more than 12.5%. The objective credential, the objective tests are the objectivity of the whole the purpose of assessment is to objectively analyze the credential of the candidate. But if the viva voce mark is allotted, 50% mark is allotted for viva voce, then that objective part is left aside and the subjective analysis comes into play.
No, see, Mr. Counsel, as on date, there is no effective relief that we can grant you. We cannot say that you will be allowed to participate in, assuming we say that the process of interview was contrary to law, we set aside or interfere. You cannot participate in that because you're overaged. This is not a case where we can even grant you opportunity to participate in immediate impending selection.
As far as I know, mid-level recruitment do happen in oil India, mid-level. So if I get an opportunity to again apply for the...
You apply, who's stopping you? Are you barred in any other way? Is there any bar by virtue of the rejection in this selection process that you cannot apply?
There may be, because I do not have the requisite experience as of now, since I was not engaged into service. So
that we cannot condone. We cannot condone that. If the advertisement, if the rules require experience, then you need experience, which essentially is not a ground raised here. You're not raising this ground that this is contrary to public policy because you're asking for fresh graduates and you're asking for experiences. You think about it. We will call up the matter again on Thursday. You think about it. Matter be called up again on Thursday. Like Learned Counsel, so and so, so and so. You think about it. If there is anything you think is still alive, we will hear the matter. Thursday, 7 and 8. Item 7, sorry.
May I please your lordship? Lordship, senior counsel, Mr. N.K. Chaudhary is on legs.
We can't help it. We can't help it. We can't help it. Who are the other counsels? He's the only counsel. Yes. What are the matters?
So far, my petition was that we have here two reason I have filed this petition for introduction to the post of DCF and to finalize the graduation leave in terms of the notification of 2011. As
You're on item number 9.
9 law. Page 28 may kindly state about.
This is the office memorandum was issued in the 2005. In terms of which the lordship second para, now therefore in supervision of earlier order, the governing body is pleased to decide that the seniority of the forest ranger appointed as per the merit list of APSC shall be fixed in order
It is a matter of seniority.
lordship. That has to be considered in terms of the on the merit list of the APSC lordship. That has not been done because even I have promoted to the post of ACF and the DCF, but my seniority has been not.
Mr. Gogoi, what is the issue here?
There are another.
Mr. Gogoi, this is a matter of seniority.
Yes, my lords.
Then,
There are fighting between two batches. One batch, my lord, went for a training. One batch, my lord, was selected by APSC. So the contention is that one batch says that in the merit list of APSC, I am the senior. Another batch contends that I have gone under training. By the dint of that merit list of the training, I'll be senior.
what does the rule say?
Rule says, my lord, to be very frank, my lord, to be from the APSC. But what has happened, my lord, time and again, sometimes this is brought into force. When my lord balance tilts, then another is brought into force.
Where are the rules? What are the rules? What are the rules?
So Assam Forest Act, my lord, rules are in still draft position. APSC has been sent, moved, my lord, the rules have to be finalized.
No, but is there any decision to place reliance on the draft rules by the Forest Department?
And then for the adjudication of this matter, I call for the record. I received this early in the evening. Only what could I gather from this document is records that, my lord, only, my lord, APSC has sought some clarifications regarding, my lord, draft rules. There is there's an interim order operating, my lord. This is 4239. 4239.
4239. These are promotions of which year? Promotions pertaining to which year?
This is pertaining to your lordship, 2020, Lord. Sorry, 2019. 2019, page 46.
Oh? 2000?
4239.
You are not prepared to argue the matter, Mr. Counsel. Twenty
2020, page 55, Lord. The juniors who are promoted to the post of PCA, your lordship.
Interim order. 2018.
Some review was also filed, is it?
Yes, my lord's review, my lord. I had placed that order on last occasion, my lord. And by dint of which were order, my lord, the
4294 has been revived.
order was tagged, my lord.
Yes. Where is the office memorandum dated 21/12/2005?
Lordship. Is page 28,
Huh?
page 28, 2005, Lordship. 2005, page 28.
28. Yes.
20 December 2005. The second paragraph is explained. Now thereof in supersession of earlier order, the governor of is pleased to decide that the interseniority of the forest officers appointed as per merit list of APSC salary fix in order of preference to the selected of APSC with effect from 1/4/86, subject to the condition that officer training must pass the training during the stipulated period, failing which is a loss.
Then the 2006, 8/2/2006,
2006, I don't have it.
and 6/10/2005.
That is not. Subsequent that they have issued in page 29, there is a notification issued. Lordship, page 29 is the, it was issued in the year 2020.
Yes. And what is the stand of the government?
When in this case, no affidavit has been filed.
My lord, that,
You're relying on some affidavits filed somewhere?
no, my lord, since the draft rule is under process,
Ah.
we are notifying that very soon.
Ah.
So once it comes out, much this will be clear. Apart from that,
Once it comes out, it will be prospective. Can it be retrospective? Can you say that it will have retrospective effect?
my lords,
If it comes out when it comes out,
In that case, my lord will take the rules, my lord, appointments. Appointment, the initial appointment, my lord, though they claim seniority from the date of appointment, but the appointment was subject to, my lord, completion of the training. It has been laid down. No, that was the, since there is, my lord, some ambiguity in the rules, my lords. This, once, my lord, they say it will be by seniority of date of
no, day means you.
day. That day is me, my lord. So, my lord, this, and also it will order number one. Rules are under process, but that only that much instructions I have, my lord.
No, but rules are under process. So in the meantime, what will happen to the seniority? What will happen to further promotions? Yes.
Yes. Lordship, the rules will have no bearing on the outcome of the case. And
Ah.
because the private respondents in item number, your Lordship, let's see, I'm led by Mr. M.K. Chaudhary, your Lordship. We are appearing for item number 8, 10, 11, 12, and 13.
Where is Mr. Chaudhary?
Lordship, he's on regs, your Lordship.
All right,
I
we'll
can
pass it over for time being.
I
Let him
can
come.
argue the matter, your Lordship.
Yes. We'll pass it over for time being if you want.
I can argue the matter, your Lordship.
Okay.
Yes.
All right.
The issue in this matter, your Lordship, is that the private respondents in item number 10, 11, 12, and
So give us the writ petition numbers.
writ petition number, your Lordship. Item number 8 is 6723 of 2013.
Yes.
That's the oldest matter, your Lordship. The subsequent matters are spin-offs from those matters, your Lordship. The private respondents were
In,
not
in
selected.
6723.
6723 of 2013. In fact, your Lordship, item number 13, which is 1148 of 2021, that takes up all the facts, your Lordship. If your Lordship can take up item number 13 for a moment, your Lordship. Only item number 13, your Lordship. I'll take your Lordship to 2 annexures. Only 2 annexures, your Lordship.
Yes.
Yes. Your Lordship may kindly come to page 33, annexure C. Page 33, annexure C, your Lordship.
Yes.
Your Lordship sees there is a list of 18 candidates. If your Lordship permits me to read the first paragraph, your Lordship. Pending finalization of draft service rule. The service rules, your Lordship, this notice is dated 28 July 1989. The service rules are still in the process of being finalized, but that will have no bearing on the case, your Lordship. The primary reason is
You read the notification.
yes, pending finalization of draft service rule, the Governor of Assam is pleased to appoint the following trainee officers who are undergoing Rangers course training at the Eastern Forest Range College, Kurseong, temporarily against the existing vacant post in so-and-so. The appointment on regular basis will be issued on successful completion of their training facilities, which they'll be liable to be discharged from service as per government OM number so-and-so. The period of training will be on probation and on production of certificate on successful completion of requisite examinations. The fixation of seniority will be determined as per order of merit in final examination of the Eastern Forest Rangers College.
Your name is included here?
Yes, your Lordship. My name and the other petitioner, Mr. Sahadat Ali, also, your Lordship. Both our names are appearing. Petition number 1's name appears in serial number 5, your Lordship.
5.
And serial number 9 is petition number 2. The private respondent's name, your Lordship, not appear in this list, your Lordship. Then comes the most important vital point here, your Lordship would kindly come to page 38. Page 38 for a moment, your Lordship. Page 38, this is a typed copy. It's a representation by the unselected candidates, your Lordship. The APSC process for 18 candidates had already culminated. Now there is a representation which is preferred by the unselected candidates, your Lordship. If I may permitted to read, your Lordship. We, the undersigned applicants, most humbly and respectfully beg to state that after facing stiff competition, undergoing rigorous selection process of written test, physical test, of long walking in sun and showers, exhaustive oral interview held by the APSC for selection of candidates for the Rangers course in Forestry 1989 to 01, we have secured the selection in the list of 44 names recommended by the APSC. We are all educated, unemployed local youth of Assam, belonging to different caste and creed and coming from different parts of it. We are all interested to serve the Forest Department of the state. And that is why we have boldly faced and overcome rigorous process of selection. We understand that the Forest Department has now more than 100 vacancies of rangers post against which the department can very well absorb all the 44 number of recommended candidates of the aforesaid APSC's list. It may not be out of place to mention here that in the last year, all of the 40 number recommended candidates were absorbed. Many of us may not have the scope for fulfilling our hopes and aspirations of being absorbed in the said post because of age and other factors if we are not absorbed from the current list. And in such case, we shall have no other alternative than to face frustration. We earnestly hope and pray that for doing justice to the selected educated unemployed local youth candidates include SC, ST, OBC, political sufferer of the state of Assam, government may be pleased to absorb all the 44 selected candidates of the APSC's, aforesaid APSC's list against the existing vacancies. Your Lordship sees the candidate's name, Your Lordship. Thereafter, Your Lordship, by a process which was not sanctioned by the APSC, Your Lordship would kindly come to page 43.
Yes.
In page 43, Your Lordship, then the ones who made that representation were appointed. Although the process by the APSC, the advertisement was for 18 posts. So that is where, Your Lordship, the crux of the matter lies. Now, it is not my case whether the service rules should be in force or not. Even if the service rules are in force, Your Lordship, they cannot legitimize illegal candidates, Your Lordship. That is where my...
Now 43 is regard to what?
Your Lordship, the 44.
43,
Yes.
43.
Page 43. Page 43 is the subsequent introduction of those candidates.
44 candidates.
Yes.
They were placed above these candidates at page 37.
Yes. Subject to, in fact, Your Lordship, there is another fact that needs to be pointed out, that subject to their marks allotted in the course in the college, the gradation list was prepared. Now, Your Lordship would see that the first 18 selected candidates were appointed pursuant to the process. Then they were deputed to go for in-service training when these candidates were not even there. Then they prepare a representation. And then by a process which is not sanctioned by the APSC, they're included in the cadre. They're included with the same people who are appointed legally. Now they've stolen a march. Now they are higher than me, Your Lordship. Now they're DFOs. That is my prime concern. Even if the marks of the college graduation was to be kept into consideration, that had to be confined in those 18 candidates. I was equated with people who were not selected. These are the records, Your Lordship. There are no further records required, Your Lordship. In fact, this Honorable Court, Your Lordship, the Supreme Court, in the matter of state of UP versus Akibuddin, has clearly spelled out that candidates who are selected illegally cannot be equated with validly selected candidates. That is my case. That is why, Your Lordship, 6723/2013 was preferred. And thereafter, Your Lordship, from item number 10, 11, 12, and 13, there are fallouts of those matters. That is the only gist of the matter, Your Lordship. There is also the issue of whether the merit.
What about the private respondents here?
The private respondents, in fact, yes, Your Lordship. Your Lordship would
KNC, Kane Chaudhary is representing them, is on legs.
Your Lordship would see at page 43, serial number 1.
All right. We take it up in the second half. Let your senior counsels be available. The short case that you are presenting is that you are regularly appointed.
Yes. That
and
is
the
my
other
only
candidates cannot be placed above you before in the gradation list.
Yes, there are two facets. One is whether my merit in the APSC seniority list can be changed by my performance in the college graduation, but that become a secondary question now. The first question before Your Lordship is whether in candidates who have been appointed by a process which is not sanctioned by the APSC, can they steal a march, can be equated with me? They've stolen a march. I prefer the writ petition. The matter is still obviously pending.
They did not appear before APSC.
They appeared, they were not selected. The 18 candidates were selected, they did not have their names here. The private respondents' names do not.
Then how the 44 were appointed?
The 44 was the larger pool of candidates which was preferred before the APSC. The APSC, based on the examination which was held, preferred 18
Selected
candidates.
18 candidates.
That is the crux of the matter. The other candidates, they preferred the representation before the authorities, saying we are unemployed local youths, with all due respect, Your Lordship, but they were not selected pursuant to the process. That is the crux of the matter, Your Lordship.
All right.
Yes.
All right.
May I please, Lordship?
Yes.
Kindly passes the matter for the time being, Lordship.
What is the matter? You're appearing on whose behalf?
Again, Lordship.
All right, pass over. What is it? What is the issue?
Lordship, that matter pertains to the dismissal from the service. Pursuant to an disciplinary proceeding, the order of dismissal has been issued by the CRPF authority.
Hmm.
And the impugned order is reflected page 49 of the repetition. Page 49 of my repetition.
We'll take it up after a while.
All right, Lordship.
Let the council be available.
Well, the petitioner is a constable. He is dismissed from service for absent from duty for about 389 days. Well, at para 2, I have stated, my lord, he was appointed on 1/1/97.
Yes.
My lord, I should have brought a list of dates, my lord, I can give it today.
That's all right. All right.
1/1, your lordship, 1/1/97, he was appointed as constable. Then 2011, my lord, 10/1/2011, he was granted 15 days casual leave while posted at Arunachal Pradesh, Tira.
Hmm.
Then he applied for 45 days leave, more earned leave, my lord. He was granted 60 days earned leave. That I've stated in para 3, my lord.
Yes.
60 days earned leave, then earned leave ended on 10/3/11.
Yes.
And supposed to resume his duties on 11/3/11, but he could not go, could not join because of his illness. So he submitted his prescription, that is at 1 series from page 20 to 28. Before the authority, he has sent it. Page 20 to 28, all these medical things he has sent it. Then 2 series, annexure 2 series, my lord, from 9, petitioner was under treatment of ENT specialist.
For jaundice.
For jaundice, my lord, ENT specialist.
Oh.
But anyway, ultimately 389 days, my lord. Then annexure 3 series, my lord, the postal receipt of sending of the prescription. And on 4/4/12, my lord, page 39.
Yes.
4/4/12, he submitted a representation going there in the office for enabling him to join, but he was not allowed to join. And from there, he came to know that office order declaring him as fugitive. May I read this representation, man? Paragraph 30, page 39.
39. Yes.
With due respect and humble submission that the applicant force number so and so would like to inform you that I was sanctioned leave on with effect from 10/1/2011 to 10/3/11. During the leave period, I suddenly fell sick on 4/3/11, and my parents brought me to the hospital at Shaharasa for treatment on medical checkup. I was diagnosed and with jaundice and hepatitis. As per doctor's advice, my treatment was going on, and I had to take rest, for which my leave period was extended beyond 10/3/11. The matter was informed to the commandant and company quartermaster of my battalion, along with all medical documents and extension of leave application by post on 31/5/2011. Again on 6/7/2011, I had informed the commandant regarding my medical treatment and rest as per doctor's advice. After recovery from jaundice and hepatitis, I was again fell sick on 9/8/11 with swelling and pain in my neck. I was taken to civil hospital by my parents. As there was no civil specialist at civil hospital, I was taken to the clinic of a Captain MS Siddiqui, a specialist. During checkup, I was informed that there is an ulcer inside the neck, and if no proper treatment is done, it may lead to cancer. I was then treated with medicines, and after a long time treatment, I was declared medically fit by the doctor on 22/3/2012. A medical fitness certificate was obtained accordingly. On 4/1/4/2012, I had traveled by train and reported to my headquarters along with all medical documents on so and so. Third, as I was absent with effect from 10/3/2011 to 3/4/2012 for a period of 389 days on medical ground. Therefore, it is my humble request kindly to sanction my unauthorized leave of absence for the remaining 389 days so that the absence could be regularized and for which
The inquiry was held in your absence.
inquiry was ultimately held on. Now, next steps they have taken is they have declared me fugitive. 4/4/10/2011, page 42, fugitive under section 31(3). Once a person is declared fugitive, he doesn't get any money. Will not be drawn any salary and allowances. So declaration of the fugitive is at page 42. This is the story they have written. Ultimately declared him as fugitive under section 31(3) of the CRPF rules. Now thereafter, my lord, departmental inquiry initiated, expertise, page 46. Memorandum of charges, page 46, my lord.
No, where is the order saying that he is declared a fugitive?
Fugitive, that is at page 42.
Okay. Under provisions of
May I,
section 31.
may I just, worship, translated copy of it, if there are desert.
Deserter, huh? That's what I was thinking. Deserter.
Desert, fugitive.
More than 90 days or something.
Yes. Page 42.
What is the term in Hindi? What is the actual term? It was conduct. Huh?
Desert.
No, no. You said it is in Hindi.
Yes, Lordship, this is,
Section 31, your lordship, you can see.
this is in Hindi, this office order.
Page section 31, your lordship. If somebody is absent for a period of 60 days, he is declared as a deserter.
Bhagoda. Deserter.
Deserter. Then
Yes.
the departmental inquiry initiated at page 46. Page 46.
Yes.
Memorandum. May I read? a departmental inquiry of the undersigned is approached from CRPF rules 1955, rule 27, against the constable so and so being member of the force, non-conformity of rules, negligence of duty, contempt of court, indictment of violations of misconduct, related summary has been attached herewith for the above given offense. Being the member of the force, disobedience of duty, negligence of duties, contempt of orders, violations and other related allegations details has been attached herewith. After reading the various details of offense which is applicable on force so and so, if investigation can be started. It is informed to the force. Wow. You see that? It is not done. It is informed to the force number so and so, constable so and so, to present himself before the inquiry officer. If not, then according to the CRPF rules 1955, rule 27 provision for, or according to the above rules, it is mentioned that if we deny from the issued order, it will be considered according to the rules of the systems that investigation is reasonably feasible. During this condition, say so and so will have to meet an investigation against the CRPF. Central Civil Service Rules 1964 of CRPF Rule 20 annumbered the attention of the constable so and so, according to which any government personnel will not try to pressurize any of his senior officer for his fulfillment of any service related to his duty, whether it may be politically or any outside pressure. If any doubtful representation is found from any other personnel in his proceedings, then it will be considered that the accused person has knowledge regarding this matter and it has been done at the request of the accused person. And according to the CRPF Rule 64, and further proceedings will be done for violation of rules.
Is there any provision for appeal when he's declared a
Yes,
deserter?
No, that provision is not there, but against the order
Against the order
of
of dismissal.
they have done. Now, detail of allegation is there.
Order of
Basically, my lord,
dismissal, or sorry, order of dismissal is pursuant to the departmental proceeding.
Yes.
yes,
Prior to that, you have declared him a deserter.
result.
So against that deserter, is there any provision for appeal under the
No.
Act rules? CRPF?
Once he is declared deserter, my lord, criminal proceeding is required to be initiated. And if he is punished in the criminal proceeding, then he can be dismissed. That I will point out. My lord, there is a nice, my lord, judgment given by Justice Ansari, my lord. My lord, this allegation say your lordship will find page 48. Basically, my lord, that unauthorized absence of duty from duty and negligence of duty. Page 48
Yes,
and 49.
yes.
This is the charge of negligence in duty and misconduct or malpractice of duty. And basically the 389 days absence without any in violation of law. May I read the charges?
Then the question of again, Parmar will come here.
My lord?
This is a judgment of the apex court,
Yes.
Krishnakant Parmar,
Yes,
where
my
it
lord.
says that absence
Willful.
will have to be found out whether it was willful.
Yes, that is there. He has given all these medical certificates and all.
So
My lord, I will come to that,
we'll
my
have
lord,
to
the lordship.
come up of the hurdle of Parmar.
He did not get inquiry report also. That your
Mhm.
lordship will have to.
Inquiry,
My
was
lord,
it sent or not?
May I just take your lordships? Then thereafter they have given this punishment. That is at page 61. Inquiry officer have not, they have examined 4 formal hearsay witness. Then deposition of witness is there, but inquiry report was not given to the petitioner. And your lordship may have specifically written, your lordship may verify from the record also. Page 61, my lord. In pune order.
Is it a part of the pleading somewhere, inquiry report?
No, inquiry report was not given to me.
So by way of affidavit, have you brought it on record?
No, inquiry report. But inquiry report it was not given to us. It is our case, one of the points in the case. Court officer has not given any opportunity to the petitioner to produce defense witnesses. My lord, page 61 is the interim judgment.
61.
The whole case has been narrated, and ultimately, my lord, same, my lord, that absence from duty from so and so date. Ultimately, my lord, it is about 389 days, and negligence of duty, the absence without any in violation of provisions of law, and accordingly, my lord, page 64. One, accused post number so and so is dismissed from service on 16/4/12. From the date of issue of this order, 16/4/12. Accused post number so and so himself reported in the battalion headquarters on 3/4/11. That's what I had stated, my lord. I went there, the petitioner went there and said, my lord, he should be allowed to join. And the access period should be, my lord, they should consider and they should against the, my lord, leave, unauthorized leave should be against the leave available to the petition. And thereafter, he was not allowed to join, and he accordingly, the inquiry proceeded expertly against him, and the inquiry report has not been given. So number one is, my lord, dismissed from service. Number two is, my lord, accused post number so and so himself reported in the battalion on 3/4/2011, and the personal's absentee period from 11/3/2011 to 3/4/2011, a total of 390 days has been regularized in dice lawn period. He would not be entitled for any salary or allowances or other facilities during this period. Well, in other cases, my lord, once he is declared deserter, my lord, he's automatically his salary and everything, they do not pay anything, suspension allowance on. The small constable, how can they expect that he will, at his own expense, he will proceed with the participate in the inquiry procedure? If any deductions or excess payment is required to be recovered against the accused post number so and so, then it would be adjusted from the amount as due to him. If the post number so and so had earned any medical or reward during his period, during his service period, then it has been deposited, conferring powers under section so and so. So everything is taken back, and accordingly the punishment has been imposed. Now your lordship will kindly see section. In my petition.
No, let us come to the charge at page 40.
Your lordship will kindly see section 9. Just I'll take your lordship to the Justice Ansari's judgment. Yeah? Section 9.
Yes.
F.
Section 9?
Oi.
Sorry.
Rule 9.
Yes, F. Deserts force.
Rule 9. Rule
Section 9.
F. Offenses and punishment. More heinous offenses. Every member of the force who deserts the force. So this is the rule.
This is section. This is section 9.
Section 9, right. Offenses, my lord. So one is, my lord, deserts. Who deserts the force? This is one offense. The lordship may just note it, my lord. Section 10, my lord.
Yes.
Less heinous offense. Then less heinous offense. Every member of the force who is in a state of intoxication when on or after having been warned of any duty or on parade or on the line of march, etc. These are less heinous offenses. And M, your lordship will kindly see, absents himself without leave or without sufficient cause overstays leave granted to him, etc.
You are reading from?
M, section 10M. Section 10, your lordship will kindly see, this is less heinous
M.
offense. Has your lordship got it?
Yes.
Then M, your lordship will kindly see, absence himself without
So
leave.
you're submitting that in order to bring him under heinous crimes, he was declared a deserter
Deserter.
and the punishment of removal was imposed.
Granted, yes,
Ordinarily, he would have been under less heinous crime.
less heinous crime. But your lordship will kindly see, section 11,
Yes.
minor punishment.
Hmm.
The commandant or any other authority or officer as may be prescribed may, subject to any rules made under this act, award in lieu of or in addition to suspension or dismissal any one or more of the following punishment to any member of the force whom he considers to be guilty of disobedience, neglect of duty, or remissions in the discharge of any duty or of any or other misconduct in his capacity as a member of the force, that is to say, reduction in rank, fine of the amount not exceeding 1 month's salary, confinement to quarters, lines or camp for a term not exceeding 1 month, confinement in the quarter guard for not more than 28 days, then removal from any office of distinctions or special emolument in the force. Any punishment specified in clause C or D or subsection 1 may be awarded by any gazetted officer when in command of any detachment of the force away from headquarters, provided he is specially authorized in this behalf by the commandant. The assistant commandant, a company officer or a subordinate officer, not being below the rank or subordinate. So this is not necessary. Now 12, your lordship will kind. 12. Place of imprisonment and liability to dismissal on service. When can a person be dismissed? Every person sentenced under this act to imprisonment may be dismissed. So person has to be imprisoned for the purpose of dismissal. Otherwise, your lordship will not find the word dismissal anywhere. May be dismissed from service. Again, I'm reading, my lord. Every person sentenced, one has to be sentenced under this act to imprisonment, may be dismissed from the force and shall further be liable to forfeiture of pay, allowances and other monies due to him, as well as of any medals and decorations received by him. Every such person shall, if he is so dismissed, be imprisoned in the prescribed prison if he is not also dismissed from the force. He may, in the court or the commandant so directs, he confined to in the quarter guard or such other places as the court or the commandant may consider suitable.
How is this relevant here?
Relevant because, my lord, it says for the purpose of dismissal, one has to be sentenced or under imprisoned. That is clear, my lord. I will take your lordship to the answer his judgment. So for the purpose of dismissal, my lord, your lordship will kindly see the more
But
heinous.
12.1 says every person sentenced under this act
Yes.
to
One
imprisonment.
has to be sentenced.
No. Any person who is sentenced for imprisonment may be dismissed.
Yes. Any
It does
person,
not-
my lord, a member
It-
of the force only.
No, but can
But your
you
lordship
be
will
read
kindly
that
say-
any person to be dismissed must be imprisoned first?
Yes, that is the judgment given by Honorable Justice
I'd
Ansari.
like to see that.
I'll provide that. My lord, your lordship will kindly say more heinous offences, your lordship will not find the order of dismissal. Less heinous offences, the order of dismissal is
No,
not there.
that we agree.
My lord.
That
But then it
had
says,
he not been declared as a deserter,
Yes.
perhaps section 9 would not have been applicable.
applicable.
Then section 10 would have been applicable.
Yes,
If 10 is there, then punishments under 11 would have been applicable.
yes,
But I don't know, subject to what
yes.
judgment you are presenting.
That
Section
is, I'll take your lordship. Now,
12.
Rule 27. Rule 27.
Rule 27. Yes.
The punishments shown as item 1 to 11 in column 2 of the table below may be inflicted or non-gazetted officers and men of the various ranks shown in each of the headings of column 3 to 6 by the authorities named below, such headings under the conditions named. Dismissal or so and so to be inflicted after formal departmental inquiry or so and so. So award of punishment, this is the rules. And the section is, my lord, I have already shown. And 31C, my lord. If a member, (31C), my lord, desertion and absence without leave. If a member of the force would become, as your lordship got in.
Yes.
Rule 31.
Yes.
If a member of the force who becomes liable for trial under clause F of section 9 or clause M of section 10, I have already taken your lordship through this. F is desertion and M is, my lord, absence from duty. 10, or for deserting the force while not on active duty under clause P of section 10, read with clause F of section 9, does not return of his own free will or is not apprehended within 60 days of the commencement of the desertion, absence or overstay of leave, then the commandant shall assemble a court of inquiry consisting of at least one gazetted officer and 2 other members who shall be either superior or subordinate officers to inquire into the desertion, absence or overstay of leave of the offender and such other members as may be brought before them. The court of inquiry shall record evidence and its findings. The courts shall the court's record shall be admissible in evidence in any subsequent department proceedings taken against the absentee. The commandant shall then publish in the force order the findings of the court of inquiry, and the absentee shall be declared a deserter from the force from the date of his illegal absence, but he shall not thereby cease to belong to the force. This shall, however, be no bar to enlisting another man in the place of the desert. So this is the position of law I'm placing it. Now your lordship will kindly see that the Honorable Justice answer his judgment that is at like C. Here. Sir, give one second. 2008 DLF 1.
Oh, judgment क्या होगा?
Let me just read it, my lord. Some small judgment, but I will try to read it because
Yes.
this is going to be the crux of my submission. Para 2, my lord, may I read?
Yes.
Briefly stated, the petitioner's case runs thus. The petitioner was appointed as a cook by the respondents in the month of July 91 and posted to so and so. Facts are more or less similar of this nature only. This 126 auxiliary battalion became 133 battalion CRPF with effect from April 94, and the petitioner continued to serve as a cook until the date of his removal from service. In the month of December 1997, on account of his mother's illness, the petitioner with due permission left his place of posting at so and so, Manipur, for 10 days on casual leave with effect from so and so. After availing sanction leave, the petitioner reported Dimapur on 31/12/97, but due to Non-availability of convoy, the petitioner stayed at so-and-so Dimapur for 2 days. During the said period of 2 days, the petitioner suffered from severe depression, and for reasons not known to him, the petitioner left his unit on 3/1/98 for his native village. But on his arrival there, he was advised by his parents and other well-wishers to go back and join his duty. The petitioner accordingly went to TC Dimapur on the next day, but could not enter into the camp due to the unknown fear, which had gripped him, and returned back to his native village at Parkating. The petitioner explained his fear to his family members, and he was taken to a badge for his treatment, but the petitioner did not improve. Whereupon the petitioner went to a doctor and remained under his treatment and gradually became fit to resume his duty. In the meantime, petitioner received a letter dated January 99, issued by the CRPF, informing the petitioner that since the petitioner had left Dimapur on 3/1/98 without reporting to anyone, the petitioner had already been declared as a deserter by so-and-so, and that a departmental inquiry had been ordered against him. By the letter dated 99 aforementioned, the petitioner was also informed that the sender of the letter, namely Sahu, assistant commentator, had been appointed as inquiry officer to conduct a departmental inquiry against the petitioner, and the petitioner had been asked to report for the inquiry at the so-and-so. Now, my lord, your lordship will kindly see para 3. This is the facts of the case. Resisting the relief sought by the petitioner, respondents have filed their affidavit in opposition. The case, after availing 10 days of casual leave with effect from so-and-so, the petitioner reported at the transit camp on so-and-so 97. But after staying there for 2 days, he deserted TC Dimapur line in the afternoon on 3/1/98 without obtaining prior permission from the authority concerned and without intimation to anyone. A court of inquiry was therefore held under Rule 31 of the Central CRPF Rules 55. As per findings of the commandant, the petitioner was declared a deserter from the Central Reserve Police Force with effect from 98, and a warrant of arrest was accordingly issued against him on 5/2/98, but the petitioner did not report for duty till 10/10/98. Thereafter, a departmental inquiry was conducted under Section 11. I have already taken your lordship for 11, my lord. With read with Rules 27 of the CRPF rules, but as the petitioner failed to produce any document in support of his illness, he was found guilty of the charges framed against him and was accordingly removed from service. The disciplinary authority awarded punishment of removal from service with effect from April 99, on the basis of the result of the departmental proceedings which had been held in accordance with the relevant rules. Now, your lordship will kindly see paragraph 5. He says, my lord, this inquiry has been held in violation of Rule 31. It has been submitted on behalf of the petitioner that the court of inquiry was held against the petitioner in violation of provisions of Rule 31 of the CRPF rules. It has also been submitted on behalf of the petitioner that there was overlapping of charges which caused serious prejudice to the petitioner. It is further submitted on behalf of the petitioner that the petitioner is a semi-literate person who studied up to class 9, and hence the petitioner was not conversant with English language. But the entire inquiry was conducted in English language, and even then the plea of the petitioner was recorded in English, and the petitioner was made to sign all the documents written in English without knowing as to what he was signing on. The inquiry so held was content Mr. So-and-so, while against the principles of natural justice, Mr. Soikia also contends that no effective opportunity was given to the petitioner to prove his innocence. Now, paragraph 7, your lordship will kindly see. These are the facts, my lord, similar to the present case. Before entering into the merits of this case, it is imperative to note that the penal provisions are embodied, among others, in Section 9, 10, and 11 of CRPF Act. Section 9 lays down punishment for more heinous offences. Section 10 lays down punishment for less heinous offences. And section 11 prescribes what minor punishments can be imposed for offences enumerated herein. Now, paragraph 8. It is in fact section 9F which provides for punishment of a person who deserts the force. The punishment may be according to section 9F as harsh as transportation for life for a term of not less than 7 years or imprisonment which may extend to as much as 14 years or with fine, which may extend to 3 months or with fine of 3 months, pay in addition to penalty of transportation and or imprisonment. That is under section 9F. That is the maximum punishment they can give. Having heard paragraph 10, your lordship will kindly see. As a matter of my lord, section paragraph 9 also, let me read it. Small paragraph. May I read?
There are 9.
Paragraph 9. Having heard both sides and upon perusal of the record, I find the submissions made on behalf of the parties are somewhat misconceived in as much as declaration of the fact that a person subject to CRPF Act is a deserter does not in itself or ipso facto make him liable for punishment. Otherwise, instead of merely declaring that a person concerned is a deserter, the CRPF Act and the rules would have provided for imposition of punishment on him under Rule 31 itself. Whereas it is Section 9 of the CRPF Act which prescribes the punishment for offense of desertion, and it is Section 12 of the CRPF Act which lays down when a person can be removed from service. A court of inquiry, it needs to be borne in mind, is neither a trial nor a disciplinary proceedings. And on the basis of the findings of a court of inquiry, no punishment can be awarded. Otherwise, court of inquiry will become a substitute for trial, disciplinary proceedings, and a person under Rule 31, instead of being declared a
But in your
deserter,
case, there was a finding that he is a deserter.
court of inquiry. By the court of inquiry.
What about the disciplinary proceeding?
Yeah, disciplinary proceeding is there, but it is the court of inquiry, I think, my lord. We'll come to that, my lord.
Where are the charges exactly? Page 40. Charges?
46, I think.
Yes, 46 is Hindi. That
This is the departmental.
these are the charges
My lord.
for the proceedings.
Yes, 48. 46 to 48.
48.
Yes.
You'll have to read it for us.
48. Let me finish this answer is judgment. My lord.
Okay. No, we wanted to find out what was the charge here.
Charges under desertion, man. 300 and negligence on duty. I'll read. Man. Let me finish with my this judgment, my lord, then I'll come back to it.
No, it is in the context of the judgment I wanted to.
48, I'll read. Man.
Oh.
That the force number so and so working in the capacity of constable so and so has done the act of insubordination, laxity in performing the duty, negligence of duty and other.
You're reading from
Page 48.
48.
Yes. Or I can go to 49 item wise, man. Detail of charges. May I read that? Page 49. that the personnel force number so and so was went on leave for 60 days of earned leave with effect from 10/1/11 to 10/3/11. He was to report his duty on 10/3/11, but he did not report his duty in the prescribed time period, and this way he was absent from duty without any prior permissions or sufficient reasons thereof from 11/3/2011, which is an offense under section 11(1) of the CRPF Act. Defiance of rules, laxity in discharging duty, negligence on duty, and misconduct or malpractice of duty. Therefore, under the instructions or order after necessary correspondence, an arrest warrant against the personnel was issued from this office on 18/6/2011. Further, neither the concerned civil police arrested and handed over the personnel to this unit, nor the personnel himself present in his duty, resulting to undertake a court of inquiry. A board is constituted by this office by order number so and so dated so and so, under the provisions to undertake court of inquiry after 60 days absent of personnel under the provisions of para 6.30 of the Battalion Officers Manual and under Rule 31A of the CRPF Rules 1955. And finally, under the office order number so and so, and as per Rule 31C of the CRPF Rules so and so, was declared fugitive on 11/3/2011 as per Rule 31C.
So this is not an inquiry to declare him fugitive. He's already been declared,
Declared,
not deserted.
not deserted.
This departmental proceeding is to, there is already a finding that he is a deserter.
He's a deserter. He sent Malak. He
So-
sent all this medical description and the order of
No.
dismissal shows. Yes.
We are trying to understand the
Yes,
charges.
yes.
The charges say that he is already declared as a deserter.
Yeah.
Therefore, now they are proceeding to award necessary punishment.
Punishment.
Therefore, the inquiry proceeds.
Therefore,
But this is not a proceeding to declare him fugitive,
that
deserter.
has been already done.
It has already been done.
Done.
Then who declares deserter? What is the procedure?
That desertion.
31.
Court of inquiry.
Rule 31.
Yes, Lordship, the court of inquiry.
It is the court of inquiry. It doesn't require any proceeding as such.
They will just take the witnesses of the personnel, Lordship, whether he is present or not. And he need not be a part of it.
He need not be means he could not be because
Because he's not there.
the preconditions are he
He's not
doesn't return or he is not arrested within 60 days. So he cannot be a part of the proceedings. Yes, Mr. Das. We can come back if you permit,
Yes.
Mr. Das.
Yes, please.
Yeah.
Justice Ansari judgment. Para 8, I have finished, my lord. Para 9 also I have finished. Para 9, again I can go through. I read para 9, my lord. Having heard both sides and upon perusal of the record, I find that the submissions made on behalf of the parties are somewhat misconceived. In as much as declaration of the fact that a person subject to the CRPF Act is a deserter does not in itself or ipso facto make him liable for a punishment. Otherwise, instead of merely declaring that the person concerned is a deserter, the CRPF Act and the rules would have provided for imposition of punishment on him under Rule 31 itself, whereas it is Section 9 of the CRPF Act which prescribes the punishment for offense of desertion, and it is Section 12 of the CRPF Act which lays down when a person can be removed from service. This section, my lord, section 12, which I have already taken through your lord. A court of inquiry, it needs to be borne in mind, is neither a trial nor a disciplinary proceeding. And on the basis of the findings of a court of inquiry, no punishment can be awarded. Otherwise, court of inquiry will become a substitute for trial or disciplinary proceedings, and a substitute for trial. Your lordship may forget disciplinary proceedings, and a person under Rule 31, instead of being declared a deserter, can be treated to have been tried absentia, and a punishment for his imprisonment under Section 9 as well as his removal from service can also be ordered in absentia. If it were so, the logical consequences will be that in such a situation, when the person who is declared deserter reports back for inquiry, he can be straightway sent to prison for undergoing imprisonment and the dismissal from service. Such a step would be against the basic concept of principle of natural justice, which forbids punishment without giving opportunity of hearing, showing cause to the accused delinquent. It is for this reason that the CRP Act and the rules, same as the Army Act and the rules, do not provide for imposition of punishment merely on the basis of deserter rule published following the court of inquiry. As a matter of fact,
But this is what the rule says.
my lord,
The rule says that the rules of CRPF does not contemplate prior hearing.
no, for the purpose of declaring desert.
Exactly.
For the purpose of declaring desert. But
So-
for the purpose of punishment, my lord, for removing him duties, one has to be, my lord, imprisonment. Imprisonment is there on the
No,
Section
no.
12.
So for if you are declared a deserter,
Yeah.
yes, then it will require some hearing,
Hearing,
proceedings.
yes.
If I
Yes,
subject for the case law, lordship, my senior is relying upon. Lordship, that position has perhaps changed. He is relying upon a judgment.
No, he is not completed. We are just
Then-
asking him queries, thoughts in our,
Judgment as a result.
you may perhaps refer to the Parmar judgment.
That will be more proper.
The judgment
That
which
judgment
my
is there.
senior is referring to,
I have,
lordship, that perhaps the position has changed because of the judgment rendered by the Supreme Court in Ghulam Muhammad Bhat. And the same was referred to by, in fact, Justice Ansari in a BB matter that was in 2012. So what he is submitting, perhaps, lordship,
I'll check. That case is also there, my lord. Otherwise, my lord, your lordship will can see when he suffered, he sent prescriptions, he appeared before the authority, but it cannot be that it is intentional. Intentionally he deserted. That factum is not there. If it is
Reflected in the records.
Yes.
But then inquiry report was never sent
said,
at his address
yes,
by post.
lordship, I have it.
The receipt says it was delivered.
Because lordship, this postal receipt,
Hmm?
lordship,
Postal
postal
receipt.
receipt is not available, but it's been sent, lordship.
Then how did you come to file an appeal against after receiving the dismissal order?
order to dismiss. Then we file an appeal. Appeal, ultimately what has happened in the disciplinary proceeding, they took the prescription to a medical officer of their own, and the medical officers opine that there is more rest than the disease which he was suffering from. It is not of that nature that he cannot attend duty. But that was done in absence. And in appeal also, but that medical opinion was taken in his absence. And the inquiry report was not given to me. If they have any proof of sending an inquiry report in my address, they will have to submit before the court.
All right, we'll come back.
Fine. Two order will show, my lord.
Yes.
Yeah, every steps that person, he has given medical certificate, he has sent medical certificate, then he reported. But it is not possible for any person to participate in an inquiry proceedings when he is not paid anything.
Hmm.
I read page 61, my lord. It is not willful on the face of the record, my lord, because every time he has sent medical report. And it is under that compulsion, my lord, he could not come and report to you within the period of 60 days.
You're reading from?
Hello?
You're reading from page number 61.
This is the impugn order.
Yes.
That being the member of the so-and-so has neglected his duty, defiance of the orders, laxity in discharging duty. The personnel took permission of casual leave of 15 days and went for his sister's marriage. Accordingly, he was to report his duty on 31/1/2011, but he did not report within the stipulated time. Rather, he submitted an application letter with a certificate regarding the division of property with his brother, which may take 30-40 days to construct a new house. So later on, instead of 45 days, he was given 60 days on leave with effect from 10/1/2011 to 10/3/2011. The personnel was to report on 10/3/2011, but he did not inform the authority within the stipulated time and is being authorized absent from 11/3/2011. That being the member of the force, so-and-so has neglected his duty, defiance of his orders, laxity in discharging duty for which the personnel was directed, instructed, a report on duty immediately by his office order dated 18/3/2011, 2/4/2011, and 14/4/2011, and also the letter dated 20/4/2011 under section 11(1), but he did not report. An application letter nil relating to extension of leave along with a medical certificate dated issued by the health and so was received, wherein it was mentioned 1 month bed rest on so 4/3/2011, 1 month bed rest on 8/4/2011, 1 month bed rest on 6/5/2011, and 1 month bed rest on 27/5/2011. This shows, Malad, this is not intentional. He has given some certificate and it is under particular circumstances he could not go. But due to more rest and little quantity of medicines prescribed in the medical certificate, the personnel was directed by letter dated 4/7/11 to undergo treatment at the nearest CRPF hospital, Muzaffarpur, to report. But due to not receiving any reply from the personnel, and therefore another letter 25/7/11 was issued, directing the personnel to report in his duty within 10 days. But even the personnel was not present in his duty, and in this way the personnel had disobeyed the order direction willfully, unauthorized absence in his duty. Under the above mentioned memorandum, proviso, item charges, details of allegations, details of documents and provisions, list of witnesses were sent to his home address or office on so. Under this office memorandum, the personnel was given 15 days time to present his report in support of his defense, but he did not present any part of his defense. As a result, to conduct a departmental inquiry, Sri Mahesh Kumar, so was appointed as an inquiry officer to conduct a departmental inquiry against the force. The copy of the letter was also sent to his home address. The inquiry officer, before intimating the inquiry, sent a letter dated so to the personnel who directed him to be present for own defense. But the personnel himself was not present and sent an application dated 16/12/11 mentioning about his jaundice and hepatitis. He also mentioned in the letter that he has swelling and feel pain in the throat from dated 9/8/11. He was undergoing treatment for which doctor advised him for 10 days leave, bed rest. The medical certificates of the persons were sent to the health officer of the headquarters unit for further investigation. The health officer made it clear.
It's not entirely without any reason. He has given reasons. He has submitted reasons.
He has submitted reasons. So things are not willful.
It's not a case of complete non-communication from his side.
Yes. So your lordship will see, whether inquiry report has been given to me. Inquiry report has not been given. Then I rely on this, this rely on the Parma case, my lord. Parma case,
Willful.
willful. That
There's
is
no,
also-
there's no willful.
There is no willful. My lord. He has submitted applications along with medical report. The medical report, they did not accept it. Father, man, they set about the medical report. No, no. 2000 Parma to bata. Parma, my lord, your lordship has gone several occasions. My lord, paragraph 16.
Yes,
May I read it again, ma'am?
certainly.
Paragraph 16. In the case of the appellant referring to unauthorized absence, the disciplinary authority alleged that he failed to maintain devotion to duty and his behavior was unbecoming of a government servant. The question whether unauthorized absence from duty amounts to failure of devotion to duty or behavior unbecoming of a government servant cannot be decided without deciding the questions whether absence is willful or because of compelling circumstances. If the absence is the result of the compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any applications or prior permission. Here, my lord, application was given, my lord, prior permission was also taken. He overstayed, may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities to which an employee may abstain from duty, including compelling circumstances beyond his control like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. In a departmental proceedings, if allegations of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. So here in this case, my lord, the medical prescription which he has submitted, that has been, my lord, that they have not accepted. Otherwise, he has submitted everything, my lord, and it is not willful. He came before the court, before the authority, and reported on 4/4/12, but authority did not accept his, and before that he has been deserted. And therefore, my lord, he was unable to get any salaries. That is not possible for him to stay in the station and participate in the inquiry. My lord, and regarding, my lord, that the inquiry report, your lordship knows that the inquiry report must be provided. The lordship will see from the record whether inquiry report has been. In the absence of that, my lord, this is also a ground for setting aside the judgment and all. My lord, in the Parma case, my lord, that last paragraph 25 is important. Paragraph 25, taking into consideration.
You're reading from,
Parma case, my lord.
Parma, paragraph
25, last.
25.
Taking into consideration the fact that the charge officer has suffered a lot since the proceeding was drawn in 1996 for absence from duty for a certain period, we are not remitting the proceeding to the disciplinary authority for any further action. Further, keeping in view the fact that the appellant has not worked for a long time, we direct the appellant be paid 50% of the back wages, but there shall be no order as to cost. I pray for this, my lord. And my lord, this notice has not been given. Your lordship will kindly see from the record.
Yes.
That, my lord, your lordship must have been given this copy. But not giving 2008 8SCC 236. We have given a copy, my lord.
Yes. This is with regard,
This is with regard to my lord not providing the inquiry report.
okay. Non-furnishing,
Paragraph 1920. This will be one. We have given specific environment is there. We have not received the copy of the inquiry.
paragraph
1920 will be my lord.
1920.
Yes.
Yes. Yes,
The reading of the inquiry report also shows that the respondent herein was not furnished with the required documentation or attest. There is no evidence to show that after submission of the report by the inquiry officer to the disciplinary authority, paragraph 20, Madam, the respondent herein was furnished with a copy of the said report along with all the, there is no evidence to show. When all these infirmities were specifically pleaded and brought to the notice of the appellate authority, he rejected the same, but he has not pointed out the relevant materials in the records of the inquiry officer. Disciplinary. Hence, the appellate authority has also committed an error in dismissing the appeal. My lord, appeal was dismissed, my lord, that your lordship will kindly record, my lord. That is at page 72, man. 72.
just 1 minute.
It discusses, my lord, the receipt of the medical certificates from the petitioner.
Paragraph,
Paragraph
sorry,
three.
page number
Sir, page 72.
72.
Appeal dismissed by 72 by the Deputy Inspector General of Police. Paragraph 6, it says, my lord, the documents have been given false. Presume on the basis of presumption, paragraph 6. And paragraph 6, my lord, the documents relating to the case were studied seriously, wherein the absence from one's duty under the section 10 without prior permission sanction of the competent authority is a heinous offense. Magistrate cum commandant in his capacity may issue arrest warrant in the name of the personnel according to section 16(2) of the CRPF Act and notification dated. It is apparent after a serious
This is
study
the
of
order, this is the order of disciplinary authority,
appeal,
appeal.
appellate authority. From nowhere it says, my lord, in appellate authority, it went further, my lord, saying that the medical certificate provided is false. But in the disciplinary proceeding, they said medical certificate, it's not a serious, not that serious, my lord, disease, where only rest is prescribed and less medicine is prescribed. Doctor has written medicines, very little, and has said to take sufficient rest. So that they did not believe. And ultimately they say it is a false group.
Yes,
So therefore I submit, my lord, in the facts and circumstances, my lord, petitioner has not willfully, my lord, remained absent. It is under particular circumstances because of his ill health and family problem. He could not be present after the expiry of the time for granting him leave. So therefore, and the disciplinary proceeding has also not proved that he has willfully, my lord, absent from duty. And therefore, my lord, I pray that the impugn order may be set aside, he may be reinstated with 50% back wages as has been held by the judgment in former case. Diploma.
Yes.
From the record, your lordship will see whether inquiry report, that is another second ground.
Yes.
I would just like to take your lordship to page 61, which my 62, which my senior had just read out. Page 62, paragraph 2.
Yes.
I'm just reading out the second paragraph. Another above mentioned memorandum provision 1, items of charge, provision 2, details of allegation, provision 3, detailed list of documents, and provision 4, list of witnesses were sent to his home address of force number so and so through registered post. Under this office memorandum, the personnel was given 15 days time to present his report in support of his defense, but he did not press any part for his defense. As a result, to conduct the departmental inquiry, Shri Mahesh Kumar, 36 CRPF, was appointed as an inquiry officer by officer order number so and so, dated 21/11/11, to conduct the departmental inquiry against force number so and so, Santosh Kumar, battalion of 36 battalion of CRPF. The copy of the letter was also sent to his home address. The inquiry officer, before intimating the inquiry, sent a letter dated 8/12/11 to the personnel who directed him to be present for his own defense. But the personnel himself was not present and sent an application on 16/12/11 mentioning about his jaundice and hepatitis. He also mentioned in the letter that he has swelling and feel pain in the throat from dated 9/8/11. He was undergoing treatment for which doctor advised him for a 10 days rest. The medical certificates of the personnel were sent to the health officer of the headquarter unit for further investigation. The health officer made it clear through a letter dated 6/1/12 that the personnel had no such serious problem. He had jaundice, but the 5 months bed rest is not justified. Even then, he is not admitted in the hospital. The following documents are not sufficient to probe his long-term absence from duty. The inquiry officer again directed a letter number so and so dated 2/1/12 to the personnel to present within 10 days or within 25/1/12 to 9/2/12. He is directed to show his physical presence before him, present his views, otherwise ex parte inquiry proceedings shall be initiated. But the personnel neither replied the letter of inquiry officer nor he was present. The EO issued the letter number so and so dated 25/10/12 to the personnel to submit 3 names of the personnel from 1 assistant constable to inspector level for his defense, so that 1 personnel out of the 3 may be appointed as it should have been defense assistant, lordship. But the said letter was not replied. Now lordship will see the medical certificates submitted by him relates to which period? that your lordship will see, our senior was relying on annexures 1 and 2 series. Annexure 1, if I include the blood test examination report, 27/5/11, your lordship will find at page 28.
This is from 4/3/11 to 27/5.
I'm coming to, I'm just indicating the period. This is still
You're referring to
27/5/11,
page number.
that your lordship will find at page 29.
No. Facts apart.
Lordship,
Now, in the face of Parmar, is there
willful.
willful? Is there any necessity now, or would you like to submit that this law has been watered down, or maybe that was rendered in the facts of this case, which are entirely different?
Parmar lordship, I cannot overcome because,
There has to be some finding that it was
but here it reflects lordship.
here.
Some
here-
medical documents were there right or wrong.
Here there is a presumption that it was willful, but there is no specific finding. There is a presumption drawn that we consulted, that doctor said, this doctor said
Right.
so. That there has to be, I suppose, a specific finding, whether
Lordship, I do not find it.
that is one.
That
The
I,
second is again whether the question of presenting officer, etc., to be appointed or not. Is it binding or not? Is again another question. We don't
Yeah.
know. Your inquiry report will reveal whether the inquiry report is not here, I suppose.
Not given to us.
inquiry report, lordship, records indicate that it has been forwarded, but I do not find
Yeah,
any.
you should have given him a copy
No,
at
no,
least
lordship, it's
by
in,
bringing it on record by way of an affidavit, at least.
They find my lord nothing, no proof of sending it.
the proof, of course, lordship, I cannot substantiate, but it appears, lordship, it has been sent, lordship.
Now, what do you say about the judgment of the coordinate bench of this court?
Lordship, my senior was referring to a judgment of Honorable Justice Ansari. That was of 2003. 3 GLR 1.
Yes.
Now, lordship, after that, there is a division bench judgment of this honorable court in 2012, 1 GLT 542. And
So let us just take down your arguments. Your first argument would be that he was a confirmed deserter.
he was declared a deserter. Lordship, there is no dispute on that. So far as desertion is concerned, lordship, it is not his prayer that the order of desertion has to be set aside. He is only on the order of dismissal. Therefore, the arguments forwarded so far as desertion is concerned, lordship, that would not have any consequence.
Yes.
Insofar as punishment, punishment, lordship, if I may take your lordship to section 11 of the Act.
Yes.
11.1. The commandant or any other authority or officer as may subject to any rules made under this act award in lieu of or in addition to suspension or dismissal any one or more of the following punishment to any member of the force whom he considers to be guilty of disobedience, neglect of duty, or reminiscence in the discharge of any duty or of other misconduct in his capacity as a member of the force. Lordship. So it is in
Yes.
lieu of or in addition to. Therefore, the power of dismissal is there.
No. Power of.
So my senior was
Dismissal.
impressing that only under section 12, if he is imprisoned, then only dismissal. That is not so. And that position has been upheld by the Honorable Supreme Court in Ghulam Muhammad Bhat. And same is reiterated in the division bench judgment of our High Court.
No. Petitioner's, Mr. Das's argument is, he was declared a deserter in order to bring him within the bracket of 9F.
Lordship, if he is not there for 60 days,
No, whatever. He is brought under 9F. And it is, if it is in 9F, of course, he is argued that he has to be imprisoned, etc., and only then dismissal can be done. But if he falls under 9F, then you have the power to impose minor punishments also
Lordship, it is
under 11.
the proceedings were Lordship under 11.1.
So if it is 11.1, that means you had already made up your mind that you are imposing minor punishments.
11.1 Lordship, that is what I was reading. Under 11.1, in lieu of or in addition to, there can be a punishment of dismissal. If I may.
But for declaring somebody to be an absconder,
Deserter,
that
is not required.
No disciplinary proceeding is required.
Once he is not there for 60 days, he does not report back or he is not apprehended, then the court of inquiry can.
Then you are saying that the inquiry report is only to see whether any.
It's only with regard to the DP.
For what? If he is declared as an absconder,
As a
deserter, he is
Yes.
entitled. He is required to be punished under 9F.
Lordship will see the charges.
More heinous.
Lordship will see the charges. At page 48. 48. Not
48
of the writ petition, Lordship. This is, of course, a translated, Lordship. I
48.
don't vouch for the correctness of the words used, but
Yes. 48.
that the force number so and so, Santosh Kumar, working in the capacity of Constable GD, has done the act of insubordination, laxity in performing the duty, negligence of duty, and other misconduct, malpractice under section 11(1) of the CRPF Act, the personnel had gone on a sanction earned leave for 60 days with effect from 10/1/11 to 10/3/11. Accordingly, he was supposed to report for duty on 10/3/11, but he did not report on the stipulated time. And he has been absent since 4/3/11 without any authorized permission, which is against the orderliness and discipline of the force. That force number so-and-so, Constable Santosh Kumar, working in the capacity of Constable GD, being the member of the force, has done the act of insubordination, laxity in performing duty, negligence of duty, and other misconduct, malpractice under Section 11(1) of the CRPF Act, under which company's letter so-and-so dated 11/3/11, 2/4/11, 14/4/11, and letter dated 24/11 issued by this office. The personnel had been directed to report for duty immediately, but he has neglected the direction and has been remained absent willfully, which is punishable offense of indiscipline. Therefore, it is basically a charge of indiscipline, Lordship.
Okay.
Now, in the division bench judgment of this honorable court, Lordship, I'll give a printout later on, Lordship. If I may just read out
What
one
is the citation at least?
yes, Lordship. 2012 1 GLT 542. It is Union of India versus Irfan Ali.
Union of India versus?
Irfan Ali.
Yeah.
In paragraph 20, it refers to the judgment of the Supreme Court in 2005-12 SCC 182, where the Supreme Court has pointed out that when a personnel belonging to a paramilitary force remains absent from duty without leave, it is a gravest misconduct, and an order of dismissal, if imposed by the disciplinary authority, ought not to be intervened with by the High Court. Here is a case, Lordship, he has been, and Lordship will just.
There is a later, very recent judgment also to that effect.
There are later judgments to this effect.
Very
recently. Very recently, perhaps I am carrying. In the other case, I was carrying it. I will give, that's a judgment, Lordship. Now, Lordship, here is a case where, in spite of going to the private doctors, he was asked by the authority, go and report to a hospital, your nearest CRPF hospital, for a better treatment. He does not do so. And the prescriptions that he gives are from private doctors, Lordship. When you are having the benefit of a better medical facility, Lordship, why should the petitioner go to a private doctor? He should have gone to the nearest CRPF hospital, Lordship. Free treatment. That is not the case, Lordship. So far as deserter, Lordship, yes, 60 days he is out. He has not reported. He is a deserter. But only thing Lordship has to see whether the disciplinary proceedings comply with the guidelines laid down by the honorables.
Yeah.
But again, that has to be tested, Lordship, whether he can be allowed to be on unauthorized leave or without leave for such a long period. I would, Lordship, fairly submit, Lordship, although the records indicate that these communications have been made, the inquiry report has been forwarded. I do not have a copy of the portion, etc. The records do not divulge that. That is my humble submission.
Well, disciplinary proceeding has been initiated because he deserted, because of the order of desertion.
No, Lordship, so disciplinary proceeding, Lordship, the disciplinary proceeding is on the question of indiscipline and on the question of indiscipline, insubordination, as per the translated copy given by my senior friend, Lordship.
The first, your lordship will see from the record whether inquiry report has been submitted. If that is not there on the face of it, it goes back. And second, it is willful or not. On the documents which are submitted showing the prescriptions of the doctors and all, was series 1 and series 2 will show that he had some certain difficulties with regard to his health and his own problem. So therefore, he could not participate. And other portion is, my lord, he was declared deserted, no payment to him. So this is another facts, my lord, where, my lord, after denying any salary to him or suspension allowance to him, if the authority asks him to participate in the proceeding, from where he is going to participate. That is another aspect of the matter. I mean, normally, my lord, in other disciplinary proceedings, we have, my lord, if suspension allowance is not given and the disciplinary proceedings is continued, my lord, because of the harshness, my lord, or the difficulties committed by the person, my lord, for non-receipt of any salary, that order of, my lord, any order possibly disciplinary sentence. On that, I will give it in normal case, not in CRP. But here the provision of law is there, and the law says, my lord, if you are declared deserted, all payment is closed. And then thereafter they expect us to, my lord, participate in the proceedings. That is another aspect of the matter, my lord.
In so far as
This
Lordship
is very, my lord,
harsh.
harsh, very harsh. And they are very low grade officer, my lord, they are constable. So therefore, I submit, my lord, this is in view of the declaration of the petitioner for desertion as the deserter, my lord. They have continued his disciplinary proceedings. So if your lordship set aside the disciplinary proceedings, the consequences will be reinstatement on them with 50% back wages as Parma case. That submission also, I'll give a judgment, my lord, if suspension was not paid, disciplinary proceeding continues. That is in violation of provision of law. I'll submit one judgment. All these documents show that he has submitted documents, steps. He is not willful and there is no finding to that.
Where was he posted?
Initially, appointed as constable, then he was
No, where was the proceedings held?
Tirap, my lord. Pansa Tirap.
Yes.
KHUNSA. District Tirap and ultimately ultimately appellate order has been passed by the DIG Guwahati.
Okay. That's all.
I have just, since he has pointed out the medical aspect of the matter, Lordship will just for a moment see page 61 of his writ petition.
61.
Page 61. How far he was suffering? Second paragraph from bottom. An application dated nil relating to extension of leave along with a medical certificate dated 4/3/11, whereas doctor signed on 4/2/11, issued by the Health and Family Welfare Department, Sarhasa, Bihar, was received wherein it was mentioned 1 month bed rest on date 4/3/11, 1 month's bed rest on 8/4/11, 1 month's bed rest on 6/5/11, and 1 month's bed rest on 27/5/11. Thereafter, since he was in Bihar, next paragraph, Lordship, but due to more rest and little quantity of medicines prescribed in the medical certificate, the personnel was directed by letter number so and so 4/7/11 to undergo treatment at the nearest CRPF hospital.
No, who directed him? By which letter?
Lordship, I. 4/7/11. I'll place it, Lordship. Oh, that's a 4/7/11. But in spite of going for a better medical facility, he opted for a private hospital, private
No,
doctor,
no,
not even
no.
hospital.
That is why, who directed
And
him?
I'll place it.
Number one. Number two, this direction must have been communicated.
Yes, Lordship.
So whether he received it.
Lordship, they are not maintaining the.
So this finding will have to be on the basis of the evidence which is adduced before the committee, that yes, by this letter he was directed, it was sent, received, something like that. But I
That receipt,
see any-
Lordship, I would fairly submit,
Yes.
it's not there, Lordship.
Yes. Anything more?
No, Lordship.
Reserved. Yes, Mr. Das. Heard reserved. Yes.
Yeah, they need Karazula, it's,
Maybe this matter may be taken up on the Thursday, Lordship, if possible.
On?
On Thursday, Lordship.
That's not possible. This is for what?
Yes, Lordship. the-
Dismissal
Yes, removal from the service, Lordship.
against CRPF.
In
Yes.
Shakespeare. And the impugn order is reflected page 49 of the repetition, Lordship. Page 49 is then. And the relevant portion is reflected there, page 53.
Yes.
Pursuant when the disciplinary proceeding, petitioner was removed from the service. The fact remains that on 2011, Lordship, petitioner was initially appointed as a constable in CRPF. Thereafter, on the 2014. when he-
You mentioned something. You wanted it matter to be
Yes,
deferred.
Lordship, we take it up on the Thursday, Lordship.
Thursday is not possible. It has to be on some other date.
Yes, Lordship. Then after 10th, Lordship.
10th or episode 8. What is the ground for challenge?
Lordship, that ground is that the charges, they have two charges has been framed against me, Lordship. One is, Lordship, that I had not intimated when I was arrested by the railway police. The evidence says this is not true. And second charges is that I was found intoxication in the railway station. Actually, on that day, I was on the leave.
All right,
And
we'll go through. List on so and so.
Machuli.
Yes, what happened?
Your Lordship had parked the matter, taken it to your. These are the preliminary 2 points, Your Lordship, where the matter rests.
Your case is that they were not regularly selected.
They were not regularly selected. The APSC selection concluded when there were 18 candidates.
But what does there are no rules.
There are no rules. But
Then this decision was taken by the government at what level?
this again, that is something that the government, the forest department would have to suffice, Your Lordship, to submit before this honorable court, Your Lordship. There was no process.
Where is the government?
There was only a representation which was given, Your Lordship, and they were taken in. In fact, if Your Lordship would kindly see. Your Lordship may kindly.
No, now
Yes,
what post are you holding?
I am an ACF, Your Lordship.
ACF.
Yes.
And the respondents?
The respondents are DFO.
So which is on a higher?
The DFOs are higher, Your Lordship.
DFOs are
The
higher.
DFOs are higher.
So what is your grievance? You are challenging their promotion
I am challenging the promotion. In fact,
on the ground that they were posted, they were placed at a higher,
Yes.
in the feeder category.
Yes,
When was the promotions affected?
the promotions were effective, Your Lordship, in the month of 2012, in the month of November, Your Lordship. That is at page 83, 84. That was the first set of promotions which were undertaken, pursuant to which we filed the first writ petition.
When was the gradation list furnished?
The gradation list, Your Lordship, was 16/10/2006.
Then why did you wait for all these years?
No, in fact, yes, Your Lordship had raised a very pertinent query, Your Lordship. In fact, if Your Lordship can kindly come to the gradation list for a moment, Your Lordship, which is at 68. For a moment, Your Lordship, page 68.
Yes.
Yes, page 68, Your Lordship, it says to the subdivisional forest officers in Assam, subject, it's a draft gradation list, Your Lordship. There was no final gradation list. which was
But you have to
published.
place your
Yes,
objections.
yes. In fact, when objections were raised in that matter, Your Lordship, this honorable court had raised 2 queries before the forest department. The 2 queries were, was the forest department
So
bound?
now their promotion, Mr. Gogoi, what is the status of their promotion? Petitioner's promotion to the next higher cadre is not been affected.
If I may submit, Your Lordship, one last point, Your Lordship.
Some of them have been promoted. In some issues, my lord, what happened, some DPs were pending. So they filed a few cases, and consequent thereto, my lord, some promotions have been undertaken. Not all the petitioners.
So both parties are now promoted to the same post.
No,
No.
what has
not-
happened
not-
is the
not all.
2006 gradation list was taken as the foundational gradation list, based on which the private respondents just stole a march over the petitioners. Now, the range, the cadre of forest rangers, Your Lordship, it includes the petitioners and the private respondents. What has happened is, in the year 89 to 91, there should have been an entry of only 18 candidates, Your Lordship. There has finally been an entry of 44 candidates, as Your Lordship has rightly seen, Your Lordship. Thereafter, as per the stipulations laid down in the advertisement, I have to be clear, Your Lordship, that the advertisements also stated that there has to be a graduating examination pursuant to which ranks will be decided. But what has happened is eventually, your lordship, I was equated to respondents who were not even selected. They were selected pursuant to after the conclusion of the APSC process. The
No, no,
APSC had
what I'm
selected.
saying is
Yes.
this selection, non-selection, etc., has to be
Yes.
subject to some rules.
There are no rules.
So
your
what
lordship.
are the
There are
rules?
rules, your lordship.
Then,
There are no rules.
so if there are no rules,
Yes.
on what basis do you say that their selection is contra
Yes.
the rules
Yes.
or
Yes.
the procedure?
Yes.
On what basis?
Yes.
You applied, you participated in a process which was advertised.
Yes. And I came as a rank holder number 1, but that is a separate issue. Your lordship, at page 19, if your lordship would see, applications for 18 stipendiary studentship for 89 rangers course in forestry. So if there are no rules, then the terms and conditions in the advertisement has to be looked into as the rules in themselves.
Where is the advertisement?
The advertisement, page 19, your lordship. Page 19.
19.
Yes, your lordship. Annexure A. Last note.
19.
Last note. 114.
114.
The advertisement is clear, your lordship.
This is 17.
Page 19, your lordship.
Huh?
Page 19, your lordship. 1148 of 2020, the last writ petition, your lordship.
No, you're dealing with the last writ petition.
Yes, yes, yes. That takes care of all the facts, your lordship.
114.
114.
Yes, your lordship. 1148 of 2021.
Page number 9.
19, your lordship. 19.
Yes.
The applications for 18 stipendiary studentship for 89 rangers course in forestry for State Forest Department, Soil Conservation Department, and District Council at the Eastern Forest Rangers College, Kurseong, to be commenced on 1st of May 1989. Will be received by the Secretary, Assam Public Service Commission, GS Road, Bhangagar, Guwahati, so and so. The candidates must be citizen of Indian Union and bona fide residents of Assam. That process culminated, your lordship, with 18 students. In fact, your lordship, after they were appointed, your lordship would be kind enough to go to page 37, your lordship. Page 37.
Can I just point out one thing? Now, Adjournment is arguing the point that beyond 18%, some persons were appointed. Where is the challenge, my lord? In which writ petition the appointments are under threat? Every time my announcement starts with that, where are the pleading? Where is the challenge? Please point out. There's no challenge much.
Page 37, your lordship. Page 37, your lordship, will indicate that the 18 candidates were deputed to go for in-service training at various forest divisions in Assam. Until this point, your lordship, there was no entry of the private respondent. The process had culminated and they were deputed.
Yes.
And your lordship, my learned senior has rightly pointed out that there was a challenge to the entry, your lordship. In fact, your lordship, there has been multiple gradation lists. There's a gradation list in 2004 also, which starts at page 44.
Yes.
Page 44 is the gradation list, your lordship, that starts, which is dated 2004. In that gradation list, your lordship, I was ranked higher than the private respondents. I was not aggrieved. I cannot be aggrieved by some entry unless their entry infringes on my right. The first instance where the private respondents stole a march over me was in the gradation list, which was dated 16/10/2006, pursuant to which there is an averment in the writ petition that we filed an objection, pursuant to which your lordship had raised this query. This query was raised by this honorable court, your lordship. (16/5/2019), your lordship, this order. Your lordship would see there are two queries which were raised. That whether the expiry of the time granted for objecting against a draft seniority, if no objections are received within the time allowed for submitting objections against draft seniority / gradation list, whether the Forest Department is required to publish any notification to treat the draft seniority gradation list as a final gradation list. There has been no answer till now, Your Lordship. And in annexure 1, Your Lordship would see of the affidavit in opposition, page 10, filed by the state respondent, reference is made to order passed by this court on 26.
Where is the gradation list that you are now aggrieved?
Yes, Your Lordship, the first gradation list is at page 68, Your Lordship. Page 60,
6-8.
68, Your Lordship, yes. Page 68 is the gradation list, Your Lordship. Now, this is the first instance, Your Lordship, where I was overtaken by the private respondents. In the earlier gradation list of 2004, I was still senior to them. I had no cause to be aggrieved.
What is your position here?
Yes, my position is, Your Lordship, petition number 1 is at serial number 167. Whole core deca, Your Lordship. 167. Your Lordship.
Yes.
Yes. Sahadat Ali, Your Lordship, petition number 2 is at serial number 150. 150.
Yes.
These are the petitioners. Thereafter, Your Lordship would see the respondents, Your Lordship. The respondent number respondent number 7 is placed at 138. 138, Your Lordship. Respondent number 8 is at 143.
Yes.
Respondent number 9 is at 140.
144.
140, Your Lordship. 140. 140.
140.
140, Your Lordship. And respondent number 10 is at 137. So this was the first instance where I was overtaken by the private respondents, more so for the fact that they were not even a part of the original 18 selected candidates. This is where the first instance of my grievance arose. And when we file an objection, this is a draft gradation list. Your Lordship would have seen the queries posed by this honorable court. There were no answers to that given. There were no answers provided by the Forest Department up until 4 years now, Your Lordship. It was a draft gradation list. There was no final gradation list. And there was abruptly a promotional exercise undertaken.
But your dates of entry are the same.
Yes, although it shouldn't have been, because I was already deputed in in-service training before my college started.
Before your?
Before the college course started in Kurseong, Your Lordship. If Your Lordship can kindly, again, for a moment, come to page 37. Page 37.
No, what is the criteria for being regularized? Is it after the training or
It is after the training, Your Lordship.
on what basis are you saying it?
Yes, I'm saying this, Your Lordship, on the basis of terms and conditions which have been laid down in the advertisement itself, Your Lordship.
Oh, advertisement.
Yes. There are no other rules in place. There are no other rules in place. In fact, the advertisement terms and conditions are in totality the entire aspect under which we entered the service. And page 37, what has happened also, Your Lordship, that we were supposed to undergo a course at Kurseong.
So where are the terms and conditions?
Yes. Your Lordship would see. The terms, in fact, the Lordship, they start from the second page onwards, where the entirety of the services are given, Your Lordship, as to what and how an individual is supposed to graduate from the college. If Your Lordship can come to page 25 for a moment, Your Lordship.
Yes.
Clause 8. In fact, it starts from clause 8 onwards until the end of the annexure, Your Lordship. It's the entirety of the terms and conditions under which were included in the Forest Department. There is one pertinent clause, Your Lordship, which, if I'm permitted, Your Lordship, at page 26, clause 10. Page 26, clause 10, Your Lordship. Your Lordship has page 26.
Yes.
Yes. The final selection for deputation to Kurseong will be made by the Chief Conservator of Forest, subject to the approval of the state government in accordance with the result of the practical training of those who are considered likely to make the best forest officer. We are never deputed to Kurseong, Your Lordship, because the college course in Kurseong had already started. That is the reason that we were deputed in service training in Assam itself. Then the Eastern Forest College in Jalukbari opened. Had we been deputed to Kurseong, Your Lordship, the private respondents wouldn't have had a claim. We could not go to Kurseong. We could not join Kurseong because the course in Kurseong had already started in the month of May. Our results were declared in the month of July. So we were deputed to go in service training. Subject to what my learned senior says, Your Lordship, the private respondents did not exist in the Forest Department till that point in time. Process had concluded. APSC had furnished a list of 18 candidates.
Now, after completion, what happened?
After completion, Your Lordship, we joined our services as rangers.
Come to page number 28,
28.
clause 16C.
Yes. On successful completion of 2 years course at Kurseong, the student will be awarded by the college authorities either the higher standard certificate in forestry or the lower standard certificate in forestry and will return to Assam to join duty. Those students who are awarded the higher standard certificate in forestry will be appointed as forest ranger in the scale of pay admissible to forest ranger, and those who are awarded the lower standard certificate in forestry will be appointed as deputy ranger in the scale of pay admissible to deputy ranger. But this had to be confined within 18 candidates. If this was confined within 18 candidates, I would not have had an issue, Your Lordship. I could not have had a claim before this honorable court.
No, you completed your training where?
I completed my training in Eastern College, Jalukbari.
Jalukbari. And what about the respondents?
The respondents also completed the course in Jalukbari.
Then?
Thereafter, after we were deputed in our respective services as rangers, there were 2 gradation lists. Your Lordship would kindly come to the first gradation list at page 44. At page 44.
Yes.
2004. It's the gradation list dated 1st of October 2004. Kukholpur Deka petition number 1 is placed at serial number 146. I am placed, petition number 2 is placed at 150. The private respondents are placed lower than me. I have no cause of being aggrieved by that gradation list. And they were not, or the petitioners and the private respondents were not appointed as rangers or deputy rangers, Your Lordship. We are all appointed as rangers. It is admitted, Your Lordship, that the petitioners did not fare well in their graduating exams from the college. That is not in dispute. But my gradation has to be within those 18 candidates.
But these 18 were meant to be sent to Kurseong.
Yes, they could not be sent because the college had already started in the month of May.
Maybe.
Yes. So we were deputed in service in various forest divisions in Assam, which is reflected in page 37. Page 37, Your Lordship would see, we were already deputed. various
Yes, all
forest,
right, okay, Mr.
but they did not exist until then.
Yes, Mr. Chaudhary.
I'll explain the position, my lord. I think the issue is, my lord, why this seniority position, why this has happened? If your lordship would kindly take this item, my lord. Please come to item WBC number 4942 of 2020, my lord. It has been filed by us. My lord, the bone of contention is the merit position in APSC list will determine the seniority. Or, my lord, the merit position in the training institute will determine the seniority. That is the issue. That my learned friend has not pointed out. Now,
Yes,
if your lordships will kindly come to my lord, page number 27 of this writ petition, my lord. The same advertisement which my learned friend has referred. My lord will kindly come to page 33. For a moment, I'll just repeat this para, then I'll take your lordships to the factual part. A candidate should note that in the event of he being selected and sent up for training, he should adopt himself to the hard and rigorous life of forest, and that when appointed in service on successful completion of training, he cannot be expected to be posted in a place where urban facilities are available. The candidates so selected will be required to join college on May 1, 1989 for undergoing 2 years training course. That means once they are selected by the APSC, my lord, then they will have to join this course. On successful completion of 2 years course at Calcium, the student will be awarded by the college authorities either the higher standard certificate in the forestry or lower standard certificate in the forestry and will return to Assam to join duty. Those students who are awarded higher standard certificate in forestry will be appointed as forest ranger in the scale of pay admissible to forest rangers. Those who are awarded lower standard certificate in February will be appointed as deputy ranger. That means, my lord, those who secure higher marks, they will be appointed as registrar, and those who secure lesser marks, they will be appointed as deputy registrar. Now, my lord will kindly come to the appointment order at page 38. Yes, in excess of 18 appointments were made, my lord. Now, lordship will kindly, my learned friend said only 18 candidates were declared. That is not correct, my lord. This is the APSC list. On results of the competitive examination held by Assam Public Service Commission for selection of candidate for Rangers course in forestry, the following candidates are recommended in order of merit. Now, my lord, Kukhal Kumar Deka, yes, respondent number 6. He is the petitioner in the other case, my lord. He secured higher position in the APSC list. There is no dispute. But the seniority will be determined not by this. It will be determined by the position in the training institute. Then serial number 6 is Sahadat Ali, is the other petitioner, my lord. Then serial number 11 is one petitioner number 1 in this case. Serial number 14. Abdul Ahmed Ali Ahmed, petitioner number 3. Serial number 17, Konak Boisho, petitioner number 4. And my lord, next page, serial number 31 is the Dibakar Das. So, my lord, in the APSC select list, their position was above up. There is no dispute whether this will determine the seniority or, my lord, the merit position in the select list. Then, my lord will kindly come to next page, page 38.
yes.
Pending finalization of the draft service rule, the governor of Assam is pleased to appoint the following trainee officers who are undergoing Rangers course training at the Eastern Forest College of so-and-so, temporarily against existing vacant post in so-and-so, so-and-so. The appointment on regular basis will be issued on successful completion of their training, failing which they will be liable to be discharged from service as per government order dated 13th of May 87. Period of training will be on probation and on production of certificate of successful completion of requisite examination. Fixation of seniority will be determined as per the order of merit in the final examination
of the Eastern Forest Ranger College. So my lord, appointment order makes it very clear, as well as the advertisement, that when they will be posted for training, they will be on probation. On successful completion of the training institute will come out with a list, and that list will determine the seniority.
This is with regard to 18.
This is the, yes, 18. Subsequently, there are other appointments made, my lord. I'm coming, my lord. So here, my lord, petitioner number 4 and petitioner number 2 are appointed. Kanak Boisya and Dibakar Das. Am I clear, my lord? Serial number 13 is Dibakar Das. Serial number 3 is Kanak Boisya. Now here, now kindly see, my lord, despite Kukhol Kumar Deka, he was serial number 3 in the APSC list. Now he is, my lord, serial number 5. Then my lord will kindly come to page number 43. On 20th November 89, pending finalization of the draft service rule, Governor of Assam is pleased to appoint the following trainee officers who were undergoing Rangers course training at Northeast so-and-so, Jalukbari temporarily against the existing vacant post. The appointment on regular basis will be issued on successful completion of their training, failing which they will be liable to be discharged from service as per the government order. The period of training will be on probation, and on production of certificate of successful completion of the requisite examination, the fixation of seniority will be determined as per the order of merit in the final examination of Northeast Rangers College. Now kindly see serial number 1, Ashok Kumar Dev Chaudhary, he is the petitioner number 1, and Mustafa Ali Ahmed, he is petitioner number 3. It is a fact, my lord, though originally 18 posts were advertised, more than 18 were appointed. And this appointment were never challenged, my lord. My learned friend's explanation to that was that only in 2006 his seniority was altered. Therefore, my lord, there was no occasion to challenge. If you are there, at least 2006 you should have challenged. Now you have never challenged our appointment. So today it is too late in the day, my lord. It will be hit by the principle of laches and, my lord, delay. Then, my lord, will kindly see. Yes. Then, my lord, page 50, the merit position in the training, that they will not annex.
No, first tell me this.
Page 50,
the
my lord.
Present petitioner's appointments were pursuant to what? The
Pursuant to, my lord, selection made by the APSC.
APSC.
Yes.
The
Then we are sent for
only
training.
point of discord is that initially there were 18 posts, subsequently
more appointments were made.
But these excess appointments,
They are also approved by, recommended by APSC.
APSC.
Yes. While the list was valid, my lord, more posts became available. That's why the list was utilized. Maybe right, maybe wrong, but that was never challenged.
No, list was utilized means there was already a merit list.
No, in merit list, our name appears, my lord. Only thing is not within 18.
That is what I wanted to know.
Yes, that's a correct. That's a correct.
So original merit list, the names were available.
Available.
So as and when the post came, they insisted on filling it up from the same merit
Yes,
list.
and that was never put to challenge by anybody. And that was in way back in 1989. Then my lord will kindly come to page 50. Now this is the final order of merit. Now this will determine the seniority.
This is pursuant to that college.
Yes. Kindly see, my lord.
Yes.
Serial number 10, second from top, Dibakar Das. He secured 70.70. Then serial number 3, my lord, Ashok Kumar Dev Chaudhary, petitioner number 1. He secured 67.12. Serial number 5, Kanak Boisya, petitioner number 4. He secured 65.50. Then, my lord, serial number 9, Mustafa Ali Ahmed, petitioner number 3. He secured 63.06. And, my lord, serial 4 from bottom, Sahadat Ali, he is one of the respondent, my lord. He secured 59.48. page 54 from bottom. I think it will be serial number 16, my lord. Sahadat Ali, he secured 59.48. Then my lord will kindly come to the next page. Now this Kukhal Kuar Deka, my lord, kindly see, my lord, he secured only 52, serial number 34. Is respondent number 6 in our case.
They are not disputing all that.
My lord,
This list,
no, the end of the day, this will determine the seniority.
no.
Ah.
The fact that these marks are there, they have been allotted, these marks are not in dispute.
No, but that never emanated from them, my lord. He never said that he secured lesser marks. Therefore, my lord, there is a circular whereby this will determine the seniority.
No, their only grievance is that these petitioners or who were the respondents
Were
beyond 18.
appointed in excess of the advertised
Excess.
vacancy.
But
And-
then
and-
you submit that your names appeared in the original merit list below 18.
But we are appointed, but that appointment was never challenged.
Never challenged.
Yes. Then, my lord, so this is the position in the merit list. Now, my lord will kindly come to page number 54.
Yes.
This is an office memorandum of December 20, 2005. Whereas prior to 1486, forest rangers were appointed only on successful completion of 2-year initial training, and accordingly, inter-seat seniority of forest rangers were fixed as per the merit list of the Rangers College. And whereas with effect from 1486, forest rangers after selected by APSC are appointed on ad hoc basis and then deputed for undergoing the 2-year training, during which they get their usual salary, etc. And on successful completion of the 2-year training, they are posted against vacancy and the training period is counted towards promotion, seniority, etc. Now, therefore, in supersession of the earlier orders, the Governor of Assam is pleased to decide that inter-seat seniority of forest rangers appointed as per merit list of APSC shall be fixed in order of preference of the select list of APSC with effect from 1486. Now, kindly see, subject to the condition that officer trainee must pass the training during the stipulated period, failing which he shall lose his seniority. Now, my lord, even as per this OAM, if the seniority is to be fixed according to the merit list of the APSC, then also they must successfully complete. They have not, they both failed in the subjects. And I'll come to the recruitment rule, my lord. Sorry, there is a notification governing the recruitment. Now, this position was altered, my lord. Now, lordship will kindly come to. So, admittedly, my lord, going by this OM of 2012-05, you will get seniority based on the APSC list, provided you complete this, successfully complete the training in time, which they did not, there is no dispute. So, even if we go by this, they cannot gain seniority over us. Then, my lord, in the meantime, my lord, we were promoted to ACF and all. Now, my lord will kindly come to page 69.
Yes.
Yes. This is a communication, my lord, issued by the PCCF to the government. Anomalies in gradation list of forest rangers. In inviting a reference to the government letter cited above, I am to inform you the following facts regarding fixation of seniority of director forest rangers as below. As per recruitment rule of the forest rangers in Assam Forest Manual Volume 2, forest rangers training, obtaining honors certificate, securing more than 75% marks in aggregate were appointed as forest ranger grade 1, as grades were there in the rank of forest rangers prior to 1964 pay commission. The trainee obtaining higher standard certificate, that is securing between 55 to 75 in aggregate, were appointed as forest ranger grade 2. Trainee obtaining lower standard certificate, securing the trainee between 50 to 55 were appointed as deputy rangers only. From the above, it is clear that seniority of forest rangers were fixed as per the merit list of Forest College, from which trainee completed their 2-year training of Forest Ranger course. In the advertisement notice issued by the APSC calling, the present application is referring, my lord. In the advertisement notice issued by APSC calling application for appointment of Forest Ranger, the condition of appointment those successful candidates with higher standard certificate in forest as Forest Ranger and other with lower standard certificate as Deputy Ranger is included in para 15C, and this shows that seniority of direct recruit Forest Rangers are fixed on the basis of final merit list prepared by the college. Accordingly, the seniority of the Forest Ranger direct recruit were fixed as per the final merit list of the course since inception up to 88-90 copies of appointment and enclosed. But due to anomaly, the seniority of 89-91 batch in gradation list of forest have been fixed on the basis of date of joining in the department, which is to be rectified as per the final merit list of the college, and this was mentioned in the appointment letters also. Therefore, revised gradation list of Forest Ranger is submitted, therewith fixing seniority of 89-91 batch as per the final merit list of college, and this may kindly be approved. Pursuant to this, my lord, that list referred to my learned friend of 2006 was issued. My lord, in the advertisement it is said, it is the appointment
This is
order.
under challenge.
Huh?
This is under challenge? In
This
their-
order, my lord, no. No.
In their petition?
No. Then my lord will kindly come to page number 93, my lord. Page 93, it's a notification dated 8th of February 2006.
Yes.
In view of the Guwahati High Court's order dated 26/8/96, passed in CR number so and so, the office memorandum dated 2012-05 is hereby kept in abeyance with immediate effect. Now, 2012-05 said, my lord, the seniority will be determined according to the APSC list, provided
You pass.
he passed the select. Then, my lord, this was overturned at page 98. Which is under challenge in the present case. 11th of February 2020, page 98. In supersession of this department's earlier notification issued by dated 8/2006, the governor of Assam is pleased to decide that internship seniority of forest rangers appointed as per merit list of APSC shall be fixed in order of preference indicated in the merit list of the APSC. Notification is issued with the approval of so and so. My lord, this is under challenge in the present proceeding. Now, my lord, in the meantime, my lord, we have been appointed as assistant conservator of forest and also as deputy conservator of forest. Huh? DFO, sorry. No. Yes. Now, my lord, Lordship has seen in that note, there is a reference to, my lord, Assam Forest Manual, Volume 2. So, a judgment was in 2010. My lord, in fact, this issue is covered by Supreme Court judge. I'll place that. Now, this is, my lord, relevant extract of the Assam Forest Manual Volume 2, which is referred in that letter of the PCCF to the government, my lord. When he said, my lord, we should revert back to the old system. If your lordship will kindly come to, my lord, page number 12, appointment. Has the lordship got it, my lord? Kindly see, subordinate forest service comprises ranger, deputy, etc., etc. Now, please come over to the next page, my lord. Ranger. The conservator may appoint the following to the class of rangers. Candidates who have obtained honors or higher standard certificate after 2 years training at the Forest College, Dehradun. Earlier, at that point of time, it was only in Dehradun. Subsequently, another was set up in Karshiang. Of course, finally, we had in our state itself, in Jalukbari on way to airport, we always notice on the left. Rangers who have obtained lower standard certificate at Forest College and who have rendered not less than 2 years of approved service as deputy ranger. So, my lord, one who secures higher standard, he alone can be appointed as a ranger. Since they fail, my lord, the question of appointing them as ranger does not arise. So, where is the question of they getting stealing a seniority over us? Now, my lord, the precise question was gone into by the Honorable Supreme Court. My lord, the judgment is 2010, Core SCC 301.
Yes.
My lord, will kindly come to the first para for the facts. Page 304, it starts. My lord, will kindly come to 305. Leave granted. Controversy in this case is with regard to the internship seniority between two batches of direct recruit forest range forest officers, that is 79 to 81 and 80 to 81 batch of graduates of so and so. The recruitment to the post of ranger in the subordinate forest service is governed by Rangers and rule, which were framed by the government of Gujarat in exercise of its power conferred under proviso to Article 309. Then para 3, Rule 3 of the 69 rules stipulated that a candidate to be eligible for appointment by direct selection should possess minimum educational qualification of intermediate examination of any recognized university or its equivalent examination comprising of subjects specified therein. Rule 7 lays down that the candidate have to undergo a selection process consisting of written test and interview. Rule 10 states that finally selected candidates have to undergo ranger course, which reads as follows. Candidates finally selected will be required to undergo training for ranger course at Northern Forest Range College, Dehradun, or so and so for a period of 2 years. Rule 11 says that state government would bear the cost for the training and that during the period of training, the candidates shall receive stipend, emoluments, etc., as fixed by the government from time to time. Rule 13 deals with appointment, which reads as follows. On successful completion of the training from the Rangers College, candidates shall be appointed as ranger if he passes with higher standard as a forester, if he passes with lower standard certificate as a forester. So, my lord, here in Assam manual it says lower standard deputy forest ranger, and here, my lord, lower standard forester. So, this is the rule. Then, my lord, will kindly come to para 36. The Undersecretary of the Forest and Environment Department had, however, put up a note on 29/9/93, evidently under pressure from the candidate of 79/81 batch, misinterpreting Rule 14 of the 69 rule, stating that candidates of 79/81 batch should be placed above the candidate of 80/81 batch. Rule 14 of the 69 rules determines internship seniority of the candidates of a particular batch and does not determine the internship seniority between the two batches whose educational qualification, year of training, and date of joining, etc. differ. Rule 14 of the 69 rules and Rule 22 of the 74 rules also further re-emphasizes that fact. The note put up by Undersecretary on 29/9/93 is therefore contrary to Rule 14 of the 69 rules and 22 of the 74 rules. The 1969, 1974, and 79 rule clearly stipulated how seniority has to be reckoned. Rule 14 of the 69 rule and 22 of the 70 rules are in perimeteria, which state that seniority of rangers will be governed by their respective ranking in the final examination and the Rangers College, irrespective of their joining the service or an actual completion of the training course. The candidates shall be appointed as rangers if they pass with higher standard certificate. So this is the catch, my lord. Both the groups are governed by these rules in the matter of their intra-seniority, and the government had rightly settled the matter of their rightly settled the seniority by order dated, and the gradation lists were also rightly published. The government, in our view, has committed a grave error in unsettling the settled seniority by its proceedings dated 29/9/93. Seniority is a civil right which has an important and vital role to play in one's service career. Future promotion of a government servant depends either on strict seniority or on the basis of seniority come merit or merit come seniority. Seniority, once settled, is decisive in upward march in one's chosen work or calling and gives certainty and assurance and boosts the morale of to do quality work. It instills confidence, praise, harmony, etc., etc. So therefore, my lord, the perimeteria provision was interpreted by the Supreme Court, and it was said that the government's attempt to unsettle it by the 29/9/93 note, my lord, that was unsettled. So that
Here,
was
here there is a set of rules
where, my lord,
in this matter.
and we have that manual, my lord.
That manual does not lay down.
No, my lord, manual. The manual is will have, my lord, at that point of time when there is no rule, my lord. It was very old of, my lord. It was, I think, long back. It is a pre-independent law, my lord. And that is the practice followed everywhere in the country, my lord. Rangers who have obtained honors or higher standard certificate after 2 years training, the question of appointment will arise merely because if somebody, my lord, clears the APSC examination, he cannot be appointed. He becomes eligible to be appointed only when he successfully completes the training with higher standard. Then, my lord, since he cannot be appointed, question of the seniority doesn't even arise. Question of seniority will come once when he is appointed. So both the petitioners, my lord, they were not even, they have not completed their training. And even if we go by the 2012-2005 circular, which says that APSC select list will determine the seniority, even then, my lord, it says you must successfully complete. So therefore, in this case, we have challenged that circular when, my lord, the practice was sought to be overturned. That is the challenge before your lordship.
And what is the stand of the government?
The government is taking the stand which is consistent all throughout, my
lord. Same stand. I found an affidavit of 2000.
Yes, yes.
And for item number 8, my lord, same stand. They have to the seniority will respond to them on the date of completion of the appointment. And thus their APSC.
So you're going back on your circular?
No, that is stayed, my lord. That has been stayed by this in our proceeding. That is stayed.
Stayed?
Yes. Earlier, there was an order that there was a review petition. We filed review. The review was allowed.
So earlier, the petition was rejected.
Until no, my lord. Yes, once, my lord, that 2012-05 was sought to be upheld. Then, when we filed a review application, my lord,
it was recalled.
The review was recalled. So therefore, my lord, the issue is not because, my lord, there were excess appointments. Therefore, all these things happened. The issue is, what would be the yardstick to determine seniority? Your position in the APSC list or your position in the training list? That is the issue. And, my lord, the judgment of Supreme Court, which of course it was there was in the Madras, in the Gujarat, there was a rule.
So in essence, you are saying that this impugned notification of 11 February
yes,
is in conflict with the manual and the long accepted practice.
And law itself.
And which Mr. Gogoi says is perfectly all right.
Yes. And in fact, my lord, I have.
You agree to this proposition?
Yes, well, I have.
So if you agree to this proposition, then your circular itself, the notification goes.
In fact, when we are looking for courts clearance, because there are earlier notifications way back in 80s. But in my lord, it was clearly held it took help of a judgment of 3 judges bench, my lord. It says recruitment is something else, appointment is something else. You are just recruited by the APSC, but appointment will come to effect only in the completion of this.
Then why are you trying to go back by way of these notifications?
Since my lord, nothing was coming, this is draft rules are under preparation. So my lord, that was the point I was hammering upon, my lord. As such, I don't have a stand as of now, but I have to adopt his argument.
No,
because
my
same-
lord, no, government stand is there.
The same, my lord.
One second, the 5, 7, 8 and 10.
In which
This is an
petition?
affidavit, my lord. We'll
My
find
lord,
it.
in 6,723 of 13,
6,723.
government affidavit is there, my lord. 5, 7, 8 বার এইটা পড়ে দিবা। আছে না তোমার?
No, but this is prior in time
No, my lord, that is the, no, my lord,
to the
maybe,
notification.
my lord, lordship knows, from time to time, my lord, until 1986, it was uniform.
We are trying to understand
Yes.
the challenge made in your writ petition,
In my writ petition, we
Your-
have challenged that
that
OM of 11th
notification.
of February.
the notification,
Yes,
which they say, which
Yes.
they agree your arguments, in which case this notification has to go.
go.
That is their argument. That is
Yes.
the query I'm putting to.
No, my lord,
government
in
counsel.
fact, my lord, all throughout the government stand was that. That's why, my lord, that letter of the PCCF to the government, which I placed, that is very important, my lord. Where the government said all throughout it was done, only in respect of these ways there are some confusion, that confusion should be set at rest.
In fact, my lord, I have original records. The letter is there, my lord.
And what is your stand in the affidavit?
Affidavit, my lord, I have to read, my lord. Okay, para 5, 6 and 7.
No, para
So
8 and
what is
12.
the status of the rules now?
No, service rule has not been framed as yet.
It's under scrutiny of the APSC, my lord. That's all I can say, my lord. There's a
My lord, with your lordship's kind permission, I mean,
Yes,
by
yes.
the court number 1 for a matter, take leave, my leave.
My lord, I'm very sorry, my lord. Item number 9, my lord, does not match with them, my lord.
It doesn't match because, my lord, he has to be
Has to be
decided.
segregated, my lord.
He has to be decided, my lord.
Yes, it has to be.
He is that purported, my lord, additional.
No, don't say item 9 or item 5. You mentioned the
Number, my lord.
number of
Lordship
the-
kindly see 4273.
No, we are in this writ petition now.
Yes, my lord.
This is 6723, where we are trying to see what is their stand in the affidavit.
My lord, in my case, my lord, does not relevant, my lord. Whatever I heard from that, my lord.
No, in your case, we'll come to your case. Let us go through the affidavit first.
6723, my lord, has got the affidavit.
Yes,
It's filed by the undersecretary,
yes. Respondents 1 and 3.
my lords. My lords, will come to page, paragraph 7.
7.
7, my lord, that the petitioner's statement made regarding preparation of draft decision list of so and so and not circulated same amongst is not true and not based on records. It may be stated, this is the crux, my lord. It may be stated petitioner's appointment letter issued provide government notification so and so dated so and so, wherein it was clearly mentioned the period of training will be on probation and on production of certificate on successful completion of requisite examinations. The fixation of seniority will be determined as per order of the merit in final examination in the college. According to the seniority of 1989-91 batch of forest rangers, including petitioners, has been placed in gradation list of so and so of 2006 as per order of merit in final examination of the colleges. The petitioner's claim for fixation of their seniority as per merit list of APSC in the slide of the office memorandum dated 2005 has no merit, as the said OM has already been kept in abeyance. Wide government notification so and so dated 2006, being violative of the provisions of appointment order of the petitioner, hence ultravirus. Para 8, my lords, that the advertisement dated so and so issued by the APSC inviting application for the post of stipendiary studentship for forest rangers course for the year 1989 to 91, wherein it was mentioned in 16C that on successful completion of 2 years course or at Kusyong, the student will be awarded by the college authorities either the higher standard certificate in forest or the lower standard certificate in
Now you
forestry.
have to get your stand in the subsequent writ petition.
My lords,
Because if this is your stand, then the last writ petition in which Mr. Chaudhary appears will have to be allowed. If you are relying on this affidavit.
it has to be, my lord, because this is 10, I cannot revert back. Only, my lord, my only hurdle I was facing that I had instructions that least rules are now being framed.
No, these are being framed, but what is the stage? Where are the rules? What is the stage? When are they coming? And in the face of your affidavit, why should we even wait for the rules?
Exactly. And even my lords, to my lord, further buttress my argument that that appointment has to be reckoned with day of the period of completion of training or the marks therein, my lord. I am relying on a judgment also. If my lord has. 1993 supplementary 3 SCC 181. There are 1993 supplementary 3 SCC 181. It's Prafulla Kumar Swain versus Prakash Chandra Mishra.
Page number?
Page number 181.
Yes.
And I'm just handing over the judgment. The relevant paragraphs are 29 and 30.
Yes.
29 and 30, my lord.
Yes.
That's all.
Yes.
That's all, my lord. Since, my lord, this appointment is subject to completion of this process, my lord, so seniority has to be bestowed only on the dependent upon the marks. My lord. That's all.
Your lordship, I'll take your lordship to only 4 NHS. Just 4 NHS.
No.
Yes.
See, whatever you have stated is a recital, is the history.
Yes.
Now, in the later writ petition of 2020, there is a circular where the government has taken a stand which is in your favor.
Yes.
Government here in their affidavit says, we go by the seniority in terms of the
Absolutely. They've
merit
done that.
as
They've
per
done
the
that.
college.
Yes.
If that be the stand,
Yes.
then that stand is contrary to the notification.
I cannot, your lordship, a stand with due submission, your lordship, a stand taken by the government, they cannot permeate illegality. They cannot permeate illegality, your lordship. My submission rests on the fact that the APSC merit list that my learned senior has relied on, the APSC merit list was confined to a certain number of candidates. There was no further sanction of any extra posts which were created.
That has not been challenged, put to challenge. There has to be a finding.
Your lordship, the challenge.
There has to be a finding.
The challenge at the first instance where I was aggrieved, your lordship. In fact, this is just
Mr. Counsel.
Yes.
You are aggrieved by the seniority.
I'm aggrieved by the seniority.
Your ground for grievance is that this people who have stolen a march over you,
Yes.
their appointments were not legal.
Yes.
Were not as per rules.
Yes.
Where is that finding?
The finding, your lordship, the records are there, your lordship. The
But
records.
where is the finding? Is it under challenge here?
It is not on the challenge.
Then?
Your lordship. In fact, your lordship, if I may permit, your lordship, no permit, your lordship.
There has to be a finding that their appointments are irregular, illegal.
Your lordship, their entry. In fact, if your lordship would come to the
By some court of law.
Yes. Your lordship, I have placed a judgment of this Honorable Supreme Court, your lordship, the list of books that have issued 1987, where this issue had been gone into. In your lordship, the judgment relied on by my senior, your lordship, would not be applicable in the fact of the case in the current matter, because the judgment relied by my learned senior, your lordship, it referred to the conflict of whether the seniority list or the merit list after graduation from the college would hold predominance, your lordship. In this matter, the conflict is between two sets of different unequally placed individuals.
First, you have to tell us that their appointments are irregular, illegal.
That they'll have to, unfortunately, the forest department had kept shut. And now they're defending on their merit list, your lordship, after the.
Mr. Counsel.
Yes.
You want a presumption to be drawn
This,
that
this is not a presumption, your lordship.
Exactly, there has to be a finding. Where is that finding? By what authority? Who has returned a finding? Who has given a finding?
Yes.
that their appointments were irregular.
Your Lordship, I'm trying to plead the same before your Lordship. That is something that I'm trying to plead before your Lordship and convince your Lordship, that their appointment prima facie is illegal, your Lordship. The process of the APSC conducted selection process ended on 28th of July 1989 when there were 18 candidates selected. Thereafter, there was a
You are
process.
asking us to draw a presumption that it is illegal without putting that to challenge. There are persons affected.
Then, if your Lordship permits or directs the APSC to file their affidavit in this matter, stating that whether the second set of influx of individuals was it under the APSC or not.
There is no dispute on the facts. There
Yes.
is no dispute
Yes.
that their appointments were made beyond 18 posts. But there has to be a finding at some level. For a finding, it has to be assailed, it has to be challenged before some court.
It has not been challenged, your Lordship.
Then-
It has not been challenged. I have to submit,
Then-
I cannot dispute on that, your Lordship. It has not been challenged.
What
has
is
been
the
challenged-
judgment you are referring to?
Yes, your Lordship. 19, what is it? No, no, my list of books are given in the morning.
Okay, we'll take it up next week.
Oh, okay.
You prepare with the lists.
My concern, my lord.
Yes,
See, my
sorry.
lord, how it is.
Item number,
Item
WPC
nine,
number,
my- Item number 9.
WPC number,
WBC 4273.
kindly pass on the 4273. Yes.
Lordship will-
4273, you are for the respondent.
No, my lord, I am for the petitioner.
He falls within those purported, my lord, extra candidates which came in by APSC, which is my learned friend.
My
is-
lord, let him say, my lord, to
Set-
file
set-
affidavit, my lord. Let me please my case, my lord.
Hmm.
Lordship will see page, page 24, my lord.
Page 24.
24, my lord. These are the APSC list comprising of 43, my number appears as serial number 2. Page 24.
No, this is for which post?
Ranger, my lord.
I'll see the date.
The same selection.
Same, my lord, I'm saying.
Yes, my lord, let
yes.
me complete, my lordship, kindly give me 1 minute time, my lord.
Ah,
Then lordship will see my serial number 2.
hmm.
Then, my lord, they have sent for training, that is page 26.
Hmm.
There, my name appears at serial number 4.
4.
4, Rubul Patak. And serial number 8, 11, and 13, my lord, Navakumar Bordoloi, 11 is Sri Kanta Kamal Deuri.
Krishna Kamal Deuri.
Krishna Kamal Deuri. They are junior to me, my lord. They have been promoted. That your lordship will see page 55.
Yes.
Page 55, lordship will see last number, my lord. FRE 16, my lord. I'm just random saying, my lord. Pradeep Kumar Sood, SCF so-and-so divisional forest officer promoted to the rank of deputy conservator of forest. Lordship has come across.
Yes.
Page 55. Then another person, my lord, lordship would see
No, pursuant to the college training, what is your position?
position, my lord. If they say, my lord, they are above me after training.
No. What is the position? We would like to see that list.
In the list, my lord, I want to project, my lord, they are below me, my lord.
So where is that list?
List, my lord, from the only 2 lists have been, could have annexed, my lord, page 26. They are below me, my lord, serial number 11 and
No,
13.
this is for sending you.
Sending you, my lord.
After completion, what is
After
it?
completion, my lord, they have not supplied with me. My lord. If they could show single document.
They have not
that
supplied,
I
you
am
have not applied.
My lord,
Did
I
you
have
ask for
applied.
it?
I have gone for training, my lord. Otherwise, my
No,
salary.
you have gone for training. We are not disputing that. What is your position?
Position, my lord, it is the department has to say. If they can say a single document, my lord, I am below the So page
So if they
57.
can't say, then on what basis are you claiming that your position is higher on this
My lord,
basis?
they have not filed their affidavit as on date, my lord.
All right, file your affidavit.
Let them clarify the stand, my lord. Then if I am below them, I have no case.
Where is that list showing their names? Is it in the pleading somewhere?
It's not in the pleadings, my lord.
No, my lord, I
But
have
in-
checked from my learned brother, it is not.
In fact, the other occasion, my lord, I had placed an order, but the benefit of that OM, my lord, that is under scrutiny now in the earlier cases.
I am not asking for the benefit at this moment, my lord.
No,
At
no,
this
no.
moment, I am
No,
asking
no.
if after
He wants
training.
to know after training, what is his position?
Yes, only that.
That pointed query I can answer, my lord. Let it.
No, I'm asking you whether that select list containing his name is a part of the pleadings in any of
No,
these.
no.
It's not there. They have not filed affidavit in my case also.
Apuna case no,
No. That's why, my lord, I am praying, my lord, to segregate this case.
my lord.
No, why segregate it now?
Because, my lord, they are
What is your prayer?
prayer, my lord, to fix my seniority, my lord. Basing on notification or, my lord,
So you are asking for placing you as per the merit position. That is your prayer number A.
prayer number A, my lord,
then-
merit position of the petition appeared in the merit list, APSC, followed by recent notification, so and so, that also goes, my lord. And B, my lord, mandamus, that promotion, provide promotion, that is already we got it.
No,
my
no,
lord.
that is the same prayer.
Yes, my lord. Only, my lord,
Same prayer.
only, my lord, if they can file affidavit showing us our position, my lord, all the problem will be over in the instant case. my lord.
Yes, Mr. Gogoi.
My lord, I'll see, since this is under scrutiny now, what will prevail? 80, this merit of APSC or my lord's training? The prayer number A. So this remains tagged. I will bring my lord his seniority.
My lord,
I
if the
will bring his
training part
position.
is given, annexed, my lord.
You
I'll
may
bring his
file, you
position.
may complete your pleadings if you want.
My lord, I can complete. I'll complete.
Yes.
I'll file affidavit. Let it remain tagged.
It's a part of the same
Same, my lord.
select list.
No, my lord, they are hesitating only for 18%. Now, my lord, apart from 18, there is a, my lord, 8 or 9% have been promoted who I said they are below me. So if they clear, my lord, that point only,
How do you say you are below or above somebody when you do not even know what is your position?
my lord, only I have annexed, my lord, 2 documents based on this APSC list and, my lord, subsequently sending training.
So
They are named
essentially
as the-
what you are saying is that a PSC list seniority has to be maintained.
No, my lord, not exactly, my lord. Now, my lord, the subsequent case developed by some other persons, other councils, my lord, if your lordship hold that the after completion of training, seniority will be determined. So I have a right to know, my lord, that my case, that seniority will.
That right to know will automatically flow, but do you have a claim to say that since your name is in a higher position in the select list pursuant to completion of training, you have a better claim?
My lord, that
is the
if
reason.
they give, my lord.
So it is all subject to the other cases. He may develop a better case if comes out in his
You
favor.
file your
I'll
affidavit
file
or furnish him the report.
Yes, my lord, that will do, my lord.
All right, we are listing it after 2 weeks.
A date may
After
be
2
fixed,
weeks.
my lord. In the meantime, let him file affidavit,
Give a
particular
date.
in item
Give a
number
date.
9.
Extra copy.
Mr. Goswami appears for respondent. In which matter? In all the matters.
No, in one case,
Kane should read it. I'm assisting Kane should read.
Okay. All right. Mr. 7 November
sir,
for,
reply.
for hearing.
7 November.
That is a lordship. Kindly pass over the day, my lord. What is this again? I am for the respondent, my lord. This is a petitioner. He wants a passover. And Mr. K. It's not well, my lord. It is submitted by the council for the respondent that the arguing council is indisposed. Therefore seeks a passover for the week. For the week. For the day.
For the day, my lord.
List accordingly. Mr. M.K. Sharma does not object. Matter stands passed over. All right. Yes. Hmm?
Lordship, matter that relates to state protection. And otherwise, the matter was actually mentioned in the morning
I think I'm told by circulation.
by circulation.
Okay. Mentioned by?
It's the SK Mehdi, his mother expired.
All right. Matter stands adjourned. At the request of the council appearing for Mr. S.K. Mehdi, as it is submitted that he is in bereavement. Matter stands adjourned for a week.
After the
Yes. There was a prayer for adjournment.
Yes, Lordship, in the morning.
So we are adjourning it for a week. They adjourn for a week.
and it came for UP.
Mr. Chaudhary, we are adjourning it for a week because there is a circulation.
Yes.
Unless you want to say that.
Let them be present.
All right. But you please organize something because otherwise it becomes difficult.
Worship.
You give a
In
thought
fact,
about.
in fact, those files-
At least you can give a thought about it.
Yes, yes, definitely I will give a thought, but here what happens, Lordship, unlike the state government where there's a team, if one council is not there, the other will represent. Here, Lordship, I have to give the file, I have to allot the case to somebody. And
No, at least the councils
it
can,
is to-
on their own,
yes, yes,
request
That must be
your
done.
office that in their absence, if it is a long absence, that is. 1-2 days is all right.
I'll do something about it.
Yes.
Pleasure.
Okay. This adjourn for a week. Give a date. None appears. To adjournment. The same person had appeared. Passed over. Yes, madam, anything?
Yes, Lordship, this is resolution filed against the Lordship, Departmental Inquiry Lordship. There is charges of embezzlement of money, Lordship. That means being the police traffic in the traffic wing, he has misappropriated the fines that has been collected from the vehicles, Lordship. We have the original record also, as Lordship has called for.
Skip it.
Lordship.
Since none appears, then we're just passing it over for the day.
Lordship.